upgraded motion matter. The same heading ought to have appeared, but I mentioned your lordship allowed, matter came, but on serial number 124, 25.
It was appearing as upgraded matter.
Yes, madam. I am playing madam.
Serial number?
Serial number madam 124, 125, 126, 127. Four similar matter, madam. Same family.
You give them notice?
Yes, I will serve notice, madam, today, madam.
Serve notice for upgradation also?
No, I have verbally told, madam, Mr. Banerjee is also appearing. I have told, madam, and Mr. Duduria appearing, madam.
If it was appearing as upgraded matter, it should be upgraded.
Well, only our affidavits are ready, but the officer comes out of station, so that it is situated in.
It's a hearing matter.
No, madam, this is.
Well, our officer will still.
No. Is it a hearing matter?
No.
Well, the court, upon the allegation filed by the petitioner, direct us file a affidavit.
Report in the form of
report in the form of affidavit.
Well, our report is ready, but the affirming officer is out of station. He will be returning on 26th. He is in Shiliguri. So we are little.
But my lord, problem is that in the pending of the writ petition, they are repeatedly issuing summon, my lord.
This is in the assistance of the inquiry.
No, but when, my lord, I am challenging entire procedure, my lord.
After 26th, you please mention once again, so that because it will serve no purpose. I'll bring it in the list, then the report is not ready.
After 26th, any day, my lord, we will.
In the meantime, my lord, kindly, my lord, they do not.
Summons, what happens? What will happen if you don't?
No, my lord, last day, my lord, his lordship mentioned, my lord, kindly see the order. His lordship, my lord, mentioned that Mr. Ryle, I mean, similar order. Thereafter, my lord, they stopped the issuing of summon, my lord.
Now the things have changed. Thereafter, whether any summons have been issued or not, my lord.
So it is said that you will be at liberty to seek adjournment.
Yes,
so
in the meantime not issued, but repeatedly, my lord, in the month of October.
Every time you seek adjournment, what is the problem?
My lord, then, my lord, on 26, I will mention, my lord.
Please mention on 26 so that it can be upgraded.
I'm grateful. I'm grateful.
May I have your lordship's kind leave to mention a matter for extension of interim order? It's expiring on 28th November.
This matter is ready for hearing and came up in 3 occasions in September.
Very well. So if hearing is not being taken up, interim order should not be extended.
Not on that.
Then
my only prayer is that kindly might not fix the hearing.
Very well. Let the interim order be extended.
Not conclude. Then your lordship.
Let it first appear for extension. When is it going to expire?
It's on 28th November.
So before 28th November, how can the hearing be concluded? Be reasonable.
Every time for the last 2 years.
Not before me.
Extension, not before
So very well. Then let it. Don't argue on this at the time of mentioning.
They are not appearing to be here.
Very well.
My lord, my petitioner's bank was attached by the for the recovery of demand and forced to close the business. My lord, I mentioned in the third time, and my clerk visited to office, but the office said the file not traceable.
কি হয়েছে কেন আসছে না ম্যাটার প্লিজ দেখি যদি না পাওয়া যায় আমার কাছে পাঠাবেন কথা বলতে বলবেন ফাইল let us see
Okay, my lord.
Again 20. Why all your matters are being non-prosecuted? All your matters are being non-prosecuted. Why? ঠিক আছে Neil, give notice to the other side also.
My lord, we are mentioning this matter for the second time. It was supposed to come on Tuesday's list under the heading to be mentioned. I'm mentioning the matter again, my lord.
For what? To be mentioned for what?
To be mentioned, my lord, in this matter, we were directed to deposit 5% of the demand of the tax. Regarding that, my senior was mentioned the matter on 12th November. And it was
supposed to mention it. You mentioned it. You are mentioning it today. You are supposed. I had asked Mr. Ghosh to mention it so that it appears on to be mentioned. I'll not be able to remember.
We mentioned this.
You mentioned it on that day. It was supposed to be mentioned on Monday so that it appears today or on Tuesday. You mention it on some day in week and then you expect it to be mentioned in the next week. That doesn't happen that way. You have to be sincere about your matter. Don't leave it on court. It's not my matter. So I will not bring it in the list unless you mention it. Now I remember what I had told.
In this matter, Your Lordship, we would have been happy if my lord could take the matter over, but unfortunately, since my lord had appeared and my lord was the bar.
लिखे नहीं? This matter.
My lord, item number 2, my lord, I'm led by Mr. Shuddhashatya Banerjee. He's unable to, he's on legs in some other court. My lord, I'm
Why
paid
you
for a not.
mentioned it?
Yes, my lord.
Then
Yes.
My lord, only
If-
one request. My lord, can I see your lordship's brief? Because the brief which has been served, whether it is a replica of your lordship's brief, my lord, only one.
what do you want to show? Tell me.
My lord, only one. My lord, only one page thereafter. If it is wrong, then my lord, then I have
Hey.
nothing to say.
Same brief, my lord, I believe has been served, but
ওনাকে দেখিয়ে দিন।
Otherwise, I'm making a day. Submission. Well, there is some difference in the.
my lord, which paid if my learned senior friend
Please
points
wait,
out.
let him. Yes. What is the
My
problem?
lord, may I just praise my
My
Yes,
lord,
Mr.
kindly see
Banerjee.
the affidavit page.
Affidavit. Yes.
My lord, and kindly compare with the affidavit. That is the.
Filled on later on. Why have you not filled up the paragraphs?
My lord, that perhaps, my
supposed
lord,
to know what paragraphs
inadvertent
are
mistake, my lord, may I see that is there in the brief, my lord.
Official copy is also there. So your lordship's copy has been done. I mean, whether after or before, we do not know.
Whatever, let us.
Yes.
You please supply him the paragraphs. He's supposed to know what paragraphs are true
We
to
shall
knowledge.
do so, my lord. We shall do so within the course of the day only.
You are not ready with your own matter. You want it to be upgraded. What kind of
Serious
mentioning is?
allegations have been leveled against the departmental officer.
Yes.
But this is an inadvertent error, my lord.
It is.
This is an error, my lord. I bowed out.
You first supply the absolute copy of the writ petition to him, saying which paragraphs are true to your knowledge and which
My
are
lord,
based on
my lord, we shall do that, my lord. In that case, may
I will not hear it today.
I will do
They don't have a complete brief.
I will supply
It
that
will
brief,
go
my lord.
back to its position.
No, my lord, can it just retain its position in tomorrow's list, my lord?
You should have made it clear.
My lord, may I just indicate
You
there
should have
is
been
extreme
sincere enough
urgency in
to-
this matter,
no,
my
sir.
lord. My lord, kindly keep it in tomorrow.
এই 3 টা গ্রুপ 4 তো নয় দিদি, আপনি 3 টা এখানে গ্রুপ 4 এ দিয়ে দিয়েছেন কেন? আর এটা তো ফর ডিসমিসাল হেডিং এ আসার কথা ছিল, সেটাও আপনি দেখেননি। এটা গ্রুপ 4 এর নয়। আজকে তো গ্রুপ 4 ছাড়া অন্য কিছু নেবে, তাহলে এখন তো শুধু শুধুই এটা ইয়ে হলো। আমার অর্ডার তো কোনো মানে হলো না, অর্ডারের তো কোনো মানে হলো না। এটা বারবার আমি বলছি, আপনি লিস্টিং এর জিনিসটা খুব অসুবিধে হচ্ছে। আর কি করবেন?
Item number 4, to start with the matter, my lord, I have little more time for instruction, my lord. If you remember, my lord, remember in this matter, my lord.
Yes, there was something with
Yes, my
uploaded.
lord. Lordship
He
asked
said
me
that
to-
it was uploaded
Yes,
later,
yes,
because that can be known. The department only will be able to
Yes,
tell
my
when it
lord.
was uploaded.
Yes, my lord. Only let it be.
The SSC will not know.
Yes, my lord.
But is it not digitally signed? It should be digitally signed.
No, my lord, this is a VAT matter, my lord.
Had here.
This is regarding recovery notice not being issued. Yeah, so the
No,
department,
but when it is uploaded on the portal, does it not require a digital signature for it being uploaded?
My lord, this
No.
is the tenure of 2018. That point of time, I think
Digital
physical.
signature was
no,
not.
it is not there.
No,
Matter.
because his specific ground
My lord,
was
this amount.
that
My lord, is yeah.
Not entire amount, the VAT and CST involved. So first we have, my lord, which amount is VAT and which amount
Yes.
is CST, we have to first clarify. That amount, my lord, I don't think, my lord, repetition is maintainable. They should approach before the tribunal.
No, my lord, that I've taken last.
Concerned, my lord. And
no, but he
My lord, we have come because of the principle of violation of natural justice.
yes, my
Section 555 clearly says.
Uh,
Yes.
physical notices are
Yes.
served. My lord,
Because
he says that he has not been served with any order, even
recovery notice.
recovery proceeding also nothing has been served.
Recovery notice has not been issued to me, my lord. That was my, and my lord had instructed me. My lord had instructed me to know the appeal status. We have filed a letter regarding this, my lord. So we have also, my clerk had also gone to the department yesterday. They said since it's an old file, they'll also take maybe 2 to 3 days more, my lord. So maybe by the next day, I'll also get the status of the appeal also, my lord.
Uh,
CST.
This matter possibly not be uploaded because it's a pre-GST matter.
very well.
Yes.
Whatever it is,
The appeal
it may
It
not
is
be
the same.
uploaded. His grievance is that he has not received any notice, any order.
Yes.
But he has filed that appeal and
You show me that you have served. That will
Yes.
do the purpose. Serve the purpose.
My lord, item number.
He said that it has been. I
has
have
been
got
deducted.
his submission.
Yes, it is there in the bank statement. I have indicated to my lord that on page 35 and page 40 of my petition, the same is already given. If you can refer to the petition.
He referred to something saying that it has also.
My lord,
been
it's there in the writ petition itself, page 35 and page 40. Bank statement
Well,
clearly
it
David.
is, this is nothing to do with the merits. Don't
Yes,
worry. ওই সেম আচ্ছা ওটা এনআর রেকর্ডিংটা করে দিন যেহেতু he has submitted, she has submitted.
I appear for the petition.
That matter.
I have filed the application.
Yes.
My
You have
application,
filed an application.
Lordships, it's on record. It is in the cause list also with CAN 1.
ক্যান কোথায় দিদি এর সঙ্গে একটা ক্যান থাকার কথা
In the cause list, it is appearing.
yes cause list it should be there in the file also.
It has to be Lordship. ডিপার্টমেন্টে ফাইল করে ক্যান যেখানে ফাইল হয় কোড নাম্বার 551 গ্রুপ কোড 551 দিস ইজ আর কোড 1211. In fact, Lordships, another the same matter which I was telling, 123 is also with CAN is showing in that also. Serial 123 for different financial year, same issue, same SSC. It is showing in
It
the
will
cause
be shown immediately once you have filed because that is computerized
system.
but the file has to come manually. Computer works faster than the
I can start this matter because any event it was done without giving an opportunity. Should be set aside. Whatever the result of the show was. Whatever. You can start the
ক্যানটা কি আজকে আনিয়ে নিতে পারবেন হ্যাঁ মামলা চলতে চলতে আনিয়ে নিতে পারবেন নালে শুধু নট টুডে করে কালকে নিয়ে নেব বিকজ আই উইল লাইক দি রেকর্ডস টু বি হিয়ার মামলা শুনে নিলাম তারপরে বললেন কালকে পাওয়া যাবে ওইটা করবেন
You can hand over the
Lordships,
for the
my
time.
copy.
দ্যাটস দেয়ার বাট মাই রেকর্ড শুড বি স্ট্রেট ম্যাটার যখন লিস্টে থাকবে তখন একবার দেখে নেবেন ক্যান
Already prejudged the issue.
yes
It was this issue.
yes
For that I like to take to some of the issues that was considered.
yes
To be considered, kindly come to the first
See.
intimation, which is it was in the shape of a TRC.
এটা
1A.
বেরিয়ে গেছে হ্যাঁ ঠিক করে দেবেন এটা মামলা হয়ে যাক তারপর ইয়েস
Lordship, let my learned friends submit, then I have some points which I'll submit.
How can it be?
no then you complete so
Lordship,
that
then I will complete.
he will not be able to answer it
Lordship, a couple of points I would like to. Lordships, I had shown your Lordships the issue of preconceived, but the judgments also and what was the order of the earlier division bench
Yes.
and post my replies. Now, Lordships, second fundamental issue which I had raised also was the invocation of section 74. Lordship, it is a case where the department alleges that I have suppressed facts. Lordship, may kindly take explanation to section 74. That explanation, for the first time, Lordship, the statute had defined.
একটু এসিটা বন্ধ করা যাবে কিছুক্ষণের জন্য? কিছুক্ষণ একটু ব্রেক দিয়ে তারপরে চালান, নাহলে আমার অবস্থা খারাপ হয়ে যাবে। আর এই জানলাটা খুলে দিন তো। 74.
74, Lordship, the explanation, it has shifted to 74A now. 74A now.
It's very cold. I am not, I am a warm-blooded person. Yes.
So, Lordship, 74A now, the explanation has shifted from 74 to 74A. Explanation 1. Explanation 2.
Explanation 2.
2, Lordships. The definition of suppression.
For capital A, 74 capital.
74 capital A. Earlier it was under 74, Lordships.
Yes.
Lordships.
For the
purpose of this act, the expression suppression shall mean non-declaration of facts or information which a taxable person is required to declare in the return, statement, report, or any other document furnished under this act, or rules or failure to furnish any information on being asked for. Lordship, what is the case before your Lordships in this case? I have filed my GSTR 3B. I have availed certain input tax credit. It is the input tax credit is auto-populating in my 2A. Now, I have submitted all my invoice copies, e-way bills, and bank payment proofs. So all the documents which are in my possession and which are in department's possession are already on record. Now, department issues a show cause notice saying that you have suppressed information. Lordship, what suppression? For the first time in GST law, Lordship, they have defined suppression. The erstwhile design, service tax and excise, it was through jurisprudence. Supreme Court and various case laws has decided that what has to be mens rea. You have to bring in the intent of mens rea if you want to invoke extended period and penalty under 74. So, Lordship, in GST law, 74 is for 100% penalty and for the extended period. This particular case before your Lordship, because it pertains to 23-24, it will not cover the extended period. If a show cause is issued under 73 also, it will not be time barred. But other matters, 18-19, which I was telling your Lordship, in that also. So for this matter, Lordship, if 74, the issuance of notice under 74 also is in challenge. Because Lordship, they have not given any point as to what suppression I have done. The only case of the department is that you have purchased goods from suppliers whose registration has been cancelled by us as they are non-existent. But at the time when registration was given, they were active, and all those facts.
But was this point not there when your first writ petition was decided? This point must have been there.
This point, Lordship, the suppression point.
Yes.
Lordship, suppression point.
The point,
Lordship.
this is a jurisdictional point.
Jurisdictional.
Yes, you are saying that for the purpose of issuance of notice under section 74, this suppression thing has to be there. Otherwise, section 74 notice cannot be issued, which is the section. This section itself says.
Lordships.
Now, this must have been a ground taken by you.
No, Lordships. No, because in that round it was only that one-liner show cause. It was only single ground. Lord, in the first writ petition, Lordships. The
division bench.
Lordships.
Remanded the matter back to the authority
to consider my pre-show cause reply.
To your pre-show cause.
Lordships. But
now, in the writ petition, when you approach the writ court saying that your pre-show cause reply has not been considered and all, was this also not a ground?
No, it was not never a ground, Lordships. 74 was not a ground, because my only plea that time before the Honorable Writ Court was that show cause is a one-liner, only single ground. And the single bench, the Honorable single bench, Lordship, coordinate bench had given one para on merits, which was not argued also. So we told the Honorable Division Bench that this discussion, one para comment on merits, should be set aside, which the Honorable Division Bench did. Because the merit was never argued. It was only a one-liner.
No, but at the stage of show cause,
Lordship,
only say at the stage of show cause, they will only say that there is suppression. They don't require to prove show cause at the stage of
Lordship. Lordship, the ingredient of suppression has to be there. Show cause means why you show cause me why this tax should not be demanded on account of suppression. That is what the scheme of the act under 74. 74 and 73 is a very marginal difference, Lordships. It says for cases of suppression, 73, non-suppression 73, suppression 74.
So what is the reason that they have given?
Lordship, they kindly take the show cause. Lordship, may kindly take the pre-show cause. The second round pre-show cause starts at 338. 338 is the second round pre-show cause, Lordship, which is a summary. 340 is the pre-show cause copy. Lordship, may I directly come to page 342.
Yes.
Lordship, 342, as per section 155, below third paragraph.
So only suppression is the ground, or fraud is also a ground?
Only suppression.
So 74, section 74 ingredients are fraud also, is it?
Fraud, willful misstatement,
So
suppression.
This kind of a situation where you may have knowledge, may not have knowledge of a person being non-existent. This is the ground that have been made out by them, saying that we have found them not to be existing there. They may be wrong, they may be right. At this stage, how can the court form an opinion that yes, this is not fraud?
Lordship, because at the time, those suppliers, the transactions which are in dispute, have already filed their returns. GSTR 1-3B is on record.
That is on paper. That is on paper.
That is on portal.
The question is on the genuineness of those documents.
Lordship, I have got out.
On the existence.
Lordship,
these kinds of cases usually keep on coming in income tax laws also, where there are cash credit, circular transactions, where everything is right on paper and everything is wrong on dirty ground. So if that is the situation here, then in that case, how can you simply say that at the show cause notice, the show cause itself is bereft of
Lordship, section 16, 4 conditions. I should have received the goods, I should have procured the invoices, supplier should have paid the tax, and I should have filed return.
Those are grounds for availment. You will avail. If these are there, then you will be entitled to avail ITC, you will be entitled to get ITC. These are the 4 ingredients. Yes, these are the ingredients.
Lordship.
Till such time that a question is not raised on the genuineness of the transaction. The moment I raise a question on the genuineness of the transactions, you will have to cross that hurdle.
Burden of proof is on me.
Barely having these 4 ingredients or culling out these 4 ingredients from the statute and showing that yes, I have complied with all this will not do, because then in that case, this test of transaction being genuine or ingenuine will be wiped out from the statute for all times to come. Everybody will have these documents. These documents are there, therefore you cannot test any genuineness of the transaction. That cannot be.
Lordship, that is what the Honorable Supreme Court has over any period held. I showed your Lordship the last judgment.
The last judgment also, you please read the
Shanti Kiran.
Yes.
Lordship.
Yes, please read the last judgment which you showed.
That there was no collusion. It was remarked that there was no collusion between the parties.
That will come out only after inquiry being conducted, not that this.
Lordship, so in the present case, Lordship, for the purpose of inquiry, I have submitted the documents.
You see, there are 2-3 things here.
Lordship.
Supreme Court judgment also, which is cited.
Lordship.
Take the last page. I have gone through it.
Lordship, page number 4, Lordships.
Page number 5.
5, Lordships. We find dispute. There is no dispute regarding the selling dealer being registered on the date of transaction, and neither the transaction nor the invoices in question have been doubted.
Yes,
Lordship.
There is a doubt here.
So, Lordship,
so there is a doubt here. This judgment does not apply to the facts of this case, at least now, because this when the matter had walked up to the Supreme Court, it had not walked up at the show cause level.
Lordships.
This has gone after a full-fledged inquiry been conducted. There is a stark difference between the stage of a fully concluded inquiry and the stage of a show cause. You cannot equate it, because once you are reading a judgment,
I am not on that.
A judgment is not to be read like a Euclid.
Lordships, I agree, Lordships. Lordship,
you have to read it in the facts of
in the whole circumstances.
So this judgment arises from a fact situation where an inquiry was wholly completed. There was an adjudication order. There was an appeal. So,
and after the High Court tribunal, everything.
Yes. So here at the stage of show cause, I will be prejudging this.
Lordship, I will satisfy why I say this case is that case where the officer has prejudged. My issue before your Lordships today, after the matter was remanded, why I say, because now the only allegation throughout in the show cause also is the retrospective cancellation of the supplier. But my submission of documents has not been dealt with at all in the show cause. That I have submitted these documents. As a bona fide supplier, purchaser, what I can supply, I have supplied. And there is no counter to that yes, these are not correct.
That they will do at the time of passing.
Lordship.
See, you are somewhat putting the authorities in a catch-22 situation. They will deal with all of it. It will be a sort of an adjudication order. You will come up to court saying that they have prejudged the issue. They don't deal with it. You come to the court saying that they have issued a show cause without dealing with my replies. They have dealt with in a manner. This is not going to be final. That I will observe. Definitely, it is not going to be final and binding because it will serve no purpose at all of issuance of a show cause. At the stage of the show cause, the most that the authority can do is that it will have a prima facie opinion that this is something. For example, in disciplinary proceedings, there also they have some evidence. They do some preliminary inquiry. They come to a finding that yes, there appears to be something wrong. They issue a show cause with the evidence that they have with them, saying that, see, we have come to a prima facie conclusion that this has happened. Now, what is your answer to that? Now, if you indict that show cause notice in court saying that no, this has not considered this has not considered that evidence, that is wrong, because at this stage, they are not required to consider at all. That is a prima facie case. You answer it. They have given a show cause to you again. You answer it saying that you have not considered this, you have not considered that. That answer to the show cause will now be taken into consideration at the time of final conclusion, where they might have other avenues to inquire into whatever you have to say. But in asking them to do everything at the first stage, so that there is no last stage at all, then the stage of issuance of a pre-show cause, stage of issuance of a show cause, then stage of an adjudication order, all of this will be bundled up into one stage, and all other stages will become OCOs. That cannot be the intention of these
Lordship.
statutes.
So, Lordship, my point is, I replied. As per the court's order, I replied.
Yes.
Now, what they have considered, if that consideration in a show cause notice is as good as an order, my point is that because
you invited that.
Lordship, they first issued me a show cause in one line that your reply is not okay.
Very well. Then in that case, you could have asked for information. What is the basis of that?
There is no scope of asking, Lordships. In the show cause, a copy paste of the pre-show cause.
That is definitely there. That scope
Lordship,
is always there in a show cause. Whenever a show cause is issued, you can always ask for the basis. In any case, what the division bench directed, you have done.
Lordships.
In terms of the division bench, they have supplied whatever information they have.
They have not supplied anything.
Yes, they have written that there are certain. I have gone through their notice also.
Lordships.
You come to the show cause.
Lordship, it is at 363.
363. 363.
Detail show cause starts at 365 onwards. Response from the undersigned authority 369 onwards.
Yes. This has rather put you in a better position because you know the mind now.
Yes.
That yes, these are certain things which they require. Which
Lordship,
whether if you are saying that these things you are not required to produce in law at all, that you can definitely go and say to them, whatever you want the court to hold at the first instance, that should go to them, because what will be the High Court doing then? The adjudicating authority, I mean, what will be the adjudicating authority doing them? I'll be doing whatever the adjudicating authority does. I will decide everything. This is not required. This is not required. This is not
Lordship,
required.
at least suppression, this court can decide if it's a judicial issue.
Suppression is not the only ground.
No,
that is what I'm saying.
Lordship, I am saying on the question of suppression, if this court, whether can Section 74 be invoked in such type of cases?
Section 74, Section 74.
That's a specific prayer also, Lordship.
Mr. Kanodia, I am not commenting on the facts and merits of this case. But is it not possible for a person to be non-existent in reality and and exist on paper? Is it not possible?
It is.
It is possible.
It is possible.
So if it is possible, then why should it be presumed at this stage that that possibility has not arisen in this case? At this stage of show cause, when I am sitting in this chair, I will not be looking at the case of the respondent being in oblivion of the case of the petitioner, and vice versa.
Lordships.
Whenever I look at your case, I will be look at your case in the surrounding facts and circumstances.
Lordships.
I cannot shut this inquiry merely on the basis of your understanding that no, since I have done business with people who have uploaded GSTR on time, I have done business with people who had their registrations in order. Therefore, all of them were existent because my paper is absolutely all right. I
That
am
is
not
what
to be
Supreme
blamed.
Court says, Lordship.
No, this again
Lordship,
I say Supreme Court has said that only upon
Lordship,
an
10th
inquiry being completed.
Lordship, 10th of November, the Honorable Justice Parviwala has entertained a writ petition which was dismissed by the Honorable Division Bench
Yes.
on the ground on the same issue. Lordship, kindly
Show
take this
cause,
judgment.
show cause.
On show cause. Para 2. Prima facie, it appears that the High Court declined to grant any relief on the ground that a petitioner has an effective alternative of going before the Commissioner GST. The principal argument of the learned counsel is that ITC cannot be denied solely on the ground of GST registration of the seller has been cancelled. In other words, goods were purchased by the petitioner wherein from a particular party and the GST registration of that party stood cancelled. In circumstances, his submission is that ITC, insofar as the petitioner is concerned, could not have been denied. Issue notice written for 8/12.
Nothing has been decided here.
Lordship, issue notice has been issued.
Nothing decided.
Nothing. I am saying notice has been issued on the same issue, and that also at show cause.
That cannot be the ratio.
I am relying on this.
Very well, you rely on that, but that is not the ratio.
Lordship, Lordships, in that case,
it is yet to be tested.
Lordship, in that case, I will withdraw the writ petition. I will prefer a statutory appeal because they have passed the order. So instead of replying, I will prefer a statutory appeal.
Statutory appeal against what?
Against the adjudication order. They have passed an adjudication order. Then I'll go to, because Lordship, participating before the same officer who has prejudged, my conscience would not allow to go before the same officer. I will prefer a statutory appeal with liberty.
He cannot withdraw, with deepest respect. Then whatever the points he has raised, he has to give and go by. In the previous writ petition, he has taken this point. What my lord asked is specific ground was that again writ petition ground. Yes, for that the petitioner thus submits that the action of the respondent number 1 to issue show cause notice where no irregular ITC has been availed, and further the ingredients of section 74 does not persist and cannot be sustained. So this was the ground he cannot raise this issue any further in this writ petition. And today, if he withdraws from all such points, it has to be on the basis of the adjudication on merits.
He has adjudicated on merits.
He has argued at length on the question of prejudged. When my lord has observed something, he now withdraws.
No, Lordship, because he has passed an order. He has passed an adjudication order. Otherwise, Lordship will direct me to file.
If
Lordship directs me to file a reply to show cause.
The adjudication order.
I will pay 10% and go.
Then what is the problem?
Well, he challenges, but he cannot take these points of prejudging issues because
I have also not decided that.
He has taken a chance. He has taken a chance. But this is all. I cannot appreciate the conduct of my officer. I also do not appreciate the conduct.
That I understand, but if he does not want to, I cannot.
But kindly observe that he has taken these points. And today, suddenly, it is not a matter of right. But when the matter is at the fag end of the hearing or my turn comes and my lord observes something, he takes it as...
Lordship, in that case, passes on. Passes an order. I will, in case Lordship direct me to file a reply to show cause, I will file again the same documents. Lordship passes.
You finish your points.
Lordship passes an order. No problem. Lordship, it will just delay the proceedings by more 3 months. No issues with that, Lordship. My senior will be happy. I am happy.
He is hoping that the officer is so blind that he will not consider his reply.
Lordship, the officer has called and threatened. I can say in open court.
If he makes personal allegation,
that is why I should not.
No.
I should not, Lordship.
Let him make a part.
I should not. I should not, Lordship, because this will derail the proceedings. And as an SSC, Lordship, I can argue a case before your lords, but the SSC has to deal with the officer day in, day out. He is the proper officer. So I have to see my SSC's interest also.
Chakraborty, these are practical difficulties which we can also understand because
I know that.
At times we'll have to see it in the larger perspective also. Because yes, in law, if an allegation is leveled against a person concerned, then in that case he has to make party you nominee. That's right. But then you cannot.
I understand.
That is why Lordship will direct me to file a reply to show cause. I will file. They will pass an order. I will go to appeal because now my rights are closed. I have to prefer a statutory appeal. He has passed the order. He has stated you have not filed a reply. I will say in the appeal that I have already, my earlier reply stands. I have nothing more to add because I cannot give any extra document, Lordships.
We do not end the issue. We go around this issue. Now he will take a point of natural justice.
No, I will not.
No, no.
On merits.
That's what he said.
Lord, that is on merits now,
That's
because he
why
has
he said-
decided on merits that I have not, that these sellers are bogus and everything. So I will now go to appeal and say, see, I have my invoice 145 burden I approved. Appellate authority if you can confirms, then I go to GSTAT lordships. After GSTAT, maybe I'll come to division bench of this court again someday.
But that is the
It will go like that, lordship, because they are passed an order now. And what has fallen from your lords during the course of hearing, these are cases wherein preconceived nature, even if there is a preconceived, even if my lords can direct that, okay, you file a reply, let adjudication be done by some other officer, I am happy with that. But lordship, going again back to the same person will make an adjudication proceeding, lordship, farce. Any of other officer of the department at the assistant commissioner level.
That, see, but then in that case, there have to be certain things on paper also, because only on the basis of oral submissions, this kind of a
Lordship,
directive
oral submission is the same, lordship.
will be
I,
having far-reaching effect.
lordship, that is why, lordship, let us,
Because the court
therefore,
cannot suddenly disown an officer of the faith that he deserves.
so
That can't be.
that is why,
can't be.
lordship. So
I can decide the writ petition, set aside that adjudication order because of it being passed on the
absolutely,
grounds of
but I-
failure of
I-
natural justice, and ask you to go, observing that these are all tentative. They can't be binding. They can't be binding.
lordship will then pass the order. Your lordship, my friend can argue, I have nothing to submit.
Any other point that
No,
you want
lordship,
to raise?
only these two.
The issue was that the person to whom he has supplied was non-existent. He was not aware of such allegations from the very inception.
Where is
But-
that?
Kindly
Where
see
can-
on
where-
page 46, the first pre-show cause notice. 47 is the relevant page, one of the last 3 lines of the
Page
paragraph.
46.
46 is the pre-show cause notice, it starts, manner. 47,
Page 46.
my lord, kindly, 47, my lord, would kindly come to the last last 5 lines. Thus, it is evident that the claim of receiving inward supply of goods by registered taxpayer, so and so.
Page 47.
Yes, madam. 47, the first paragraph, last 5 lines.
Thus it is evident. Yes.
My lord, kindly say, who never existed and never conducted business from their declared place of business. This is a classic case of collusion, my lord. My lord, that is was the allegation that they never conducted their business from that place and never existed, are fabricated and have no actual base. ITC have been claimed and so in contravention. So, my lord, he was aware of it. Now, my lord, when he is dealing with this situation, he answers kindly. Now, his reply, page 59. Because, my lord, I am saying there is no movement of goods. Basically, my lord, it's no movement of goods. Well, I'll just.
Yes.
Paragraph 59 would kindly come to.
Page 59.
Yes, 61, paragraph 5.
P1.
Paragraph 5. My lord, what he says, in furtherance of the above,
Just a minute. It's 61. Yes.
paragraph 5. My lord. In furtherance of the above, the notice would like to state they have received proper GST invoice from the vendor and have made payments to the vendor. Additionally, the supply has also been received from the supplier and input tax credit on the same is also appearing in GST at 2A or so and so. Further, to address the allegation that there is no actual supply of goods, the notice is hereby attached the EOA bill as evidence to demonstrate the actual receipt of the goods. So when he is aware that the allegation is that there was no actual supply, all paper transactions. Now kindly come to one paragraph 12. But he has given a reply of 150 with all the judgments pages. At the stage of paragraph 12 onwards, he relies upon the judgment. Now, my lord, kindly see. Pinpointed to that fact. Thus, the notices states my paragraph 20, my lord.
Yes.
Without prejudice, means last 5 lines. Noticee has received the goods and consequently have claimed input tax credit. Hence, the intimation proposing recovery of tax along with interest and penalty of equivalent amount of credit availed cannot be sustained and liable to be quashed. Now, my lord, the division bench is order, which is at page 333. Volume 3, 50.
Full three.
But paragraph 6, I'm just sorry, man, it starts 333. I'm relying on paragraph 6 and 7. It is not in dispute that the appellants have submitted a detailed explanation and also enclosed certain documents and relied upon various decisions. Thus, when the authority has thought fit to exercise its power under section 74(5), he is enjoined upon a duty to consider the reply before it take a decision to issue a show cause notice under section 74(1) of the Act. Duty to reply before it and takes a decision to issue a show cause. But this was the specific statement or the specific finding of the Honorable Division. Finding, there has to be a finding. Now, my lord, would kindly come to paragraph 7. Therefore, we are of the view that the authority should consider the reply dated so and so to the intimation issued earlier. Deal with those issues. When dealing with means I have to give a finding to it in view of the paragraph 6. It is not only when I deal with it and do not express my mind. These are the two words. Dealing with come with some consequences. Now, my lord, would kindly come to 368. The DRC 01 starts from page 365. 368, I consider whatever he has replied to. 368, my lord, would kindly come to the Roman 2.
Roman 2.
Yes, my lord, 368 Roman 2, my lord, in his reply. They have received proper GST invoice from the vendor. I have made payments to the vendor. Additionally, the supply has also been received from the supplier, and input tax credit on the same is also appearing in GST or 2A of the notice, and making the noticee eligible to avail to ITC. Further, to address the allegation that there is no actual supply of goods, the noticee is thereby attaching the e-way bill as evidence to demonstrate the actual receipt of goods. Well, this was now how I consider this. My lord, would kindly come to page 370. 370. Thus, merely furnishing of e-way bills and weighbridge receipts, bank statement, invoices, and copy of ledger from books do not prove the transactions were bona fide and there was actual movement of goods and the goods were actually received by you. You do not furnish proof of payment of freight charges, so and so. The prima facie, the document furnished by you is not conclusive. Well, today, if I do not express my mind, do not express how he will answer to it. Well, he can have a legal answer that in law I do not need to disclose this, or in fact he will disclose the actual documents which the authority is wanting from me. It can be both ways, but he chooses not to do any of it. And this is what can and I cannot lose for both head and tail. Once I have been prosecuted for not dealing, not giving a finding, and now I am being prosecuted for giving a finding, prima facie finding. If my lord would find everywhere I have said this is a prima facie, which can be rebutted by them. It's a prima facie finding, man. But I have to give a minute. I have to act in terms of the division bench's order, and he has given us such a lengthy answer to the show cause notice. But if I have to deal with each and every, I had done it with my whatever in my capacity. Whatever possible, that's a prima facie opinion. Now the evidence has to be adduced. Whatever he will be an opportunity to reply, answer. 75(2) says the appellate authority can also reduce the can change the section from 74 to 73. That power is given to the appellate authority. He is protected. But GST code is a complete code by itself. Just because the tribunal is not functioning, we are approaching your lordships. But in normal, it's a complete code by itself, wherein actual justice has been built in it, inherent in
His
it.
submission was that these documents are not required because e-way bills contain all the particulars.
But this has to be done, decided in an adjudicating proceedings. Well, today, my lord has given a
No, but if the documents on the basis of which you want to nail a person, the purpose of those documents are served by another document which is there on record.
My lord, I bow
Should
down.
you still
My lord,
proceed?
my lord, question is whether this finding will come before at the stage of show cause or after the show cause, after he has replied, because now he knows my mind that I'm not satisfied with this document. He can very well come up and say this same thing, that the law does not permit or law does not give any does not allow me to give any other documents. You should be satisfied whatever you have got. But that it should be his answer. But today, my lord, kindly appreciate our authority. Power cannot be restricted by saying, well, there are paper transactions. There are companies, there's a specific finding in a parallel proceedings that this, whoever the suppliers were non-existent. This is a classic case of collusion. This transaction never had taken place. Now he gives certain documents. The authority says at the stage of show cause, I'm prima facie not satisfied with the with your answer, and issues a show cause. It is not the end of the road. Now, my lord, would kindly the judgments my learned friend has relied upon. My lord, just before that, my lord, I rely on a Supreme Court judgment. This is also on show cause, but it is in the central excess. My lord, kindly come to paragraph 4 and 5. Justice Larit's judgment.
Paragraph 4.
Preliminary objection and decided to proceed in the matter. It further decided that from the facts available on record, it appeared that manufacturing activity was being undertaken by the respondent without following due procedure, without paying any excise duties observed. After the aforesaid opening recital, the facts were considered. Finally, the respondent was called upon to show cause. But he challenged this by way of a writ petition. Thereafter, forum, he went up to, after ultimately the issue went up to Supreme Court. The authorities had challenged the challenges from the end of the authorities. Paragraph 4. Mr. Bakchi, learned advocate, submitted the process of adjudication has never taken place. There was no response to the show cause notice. Nothing was submitted by the respondent denying or disputing the assertion made in the show cause notice, and the matter was considered by the appellate authority and the tribunal from completely incorrect perspective. According to her, in cases such as the present one, where the manufacturing process was undertaken, the goods were cleared without payment of any excise duty, the show cause notice itself would not cover only the basic issue whether the process so undertaken amounted to manufacture or not, but also the resultant liability in case the process in question amounted to manufacture, and it would always be open to the assessee to make such submissions touching upon both the issue. And the proper course was to let the proceedings pursuant to the show cause notice to be taken into a logical conclusion. Mr. Swan's learned advocate for the respondent submitted that the internal order dated so and so had taken a view that the process amounted to manufacture, and such assessment was arrived at without affording any hearing to the respondent. So in the show cause, it was said that it is that this process amounting to manufacture, and this is a finality according to the authorities. That's why it was entertained in the High Court and so and so. Now, my lord, ultimately, what the Supreme Court has. Paragraph 30. It must be noted that while issuing a show cause notice,
Yes.
under section 11 capital A of the Act, what is entertained by the department is only a prima facie, on the basis of which the show cause notice is issued. The determination comes only after a response or representation is preferred by the person to whom the show cause notice is addressed. As a part of his response, the person concerned may present his point of view on all possible issues, and only thereafter the determination or decision is arrived at. In the present case, even before the response could be made by the respondent and the determination could be arrived at, the matter was carried in appeal against the said internal order. The appellant was therefore justified in submitting the appeal itself was premature. It has been laid down by this court that in the excise law is a complete code in nature. It would normally not be appropriate for a reed court to entertain a petition under Article 226 of the Constitution, and that the person concerned must first all the objection before the authority who has issued the show cause notice, and the redressal in terms of existing provisions of law could be taken resort to if an adverse order was passed against such person. For example, in so and so, excise law is a complete code in order to seek redress in excise matter, and hence may not be appropriate for the reed court to maintain a petition under Article 226 of the Constitution of India. The High Court and so, paragraph 15. It is thus well settled that the reed petition should normally not be entertained against the mere issuance of show cause notice. In the present case, no show cause notice was ever issued when the High Court had initially entertained the petition and directed the department to prima facie consider whether there was a material to proceed with the matter. So and so. Well, thereafter, he has considered the income tax matters and he has distinguished there and let the law down. Well, this is also a complete call. Well, there will be an adjudication, appellate authority. If tribunal is functioning, there is a tribunal. But he has 3 or 4 layers to it, to his challenge. It is just a prima facie finding, and he has invited this finding. But I have expressed my mind, which was directed by the Honorable Division Bench, so that he is in a position to understand my mind and answer to. Now, my lord, the judgments my learned friend has relied upon. He is senior to me in terms that my lord, he knows this law much better than I do.
No. Everybody of us are learned.
409.
No, he knows the law very well.
He knows. That's what I say, my lord. He knows the law, and I always try to learn from him.
Even I am learning now.
No, not.
Because before that, I did not know about
Well,
this.
difficulty,
GST.
I cannot keep up to his pace now. It's so
Nothing.
fast.
Yes,
I think
next.
all chartered accountants are fast. Faster. My lord, kindly see the audits. He has relied heavily on audits.
Oryx Fisheries.
Yes, Oryx
It's
Fisheries.
annexed, I think, to the
Yeah.
409, my lord, 409.
page
409. 409.
409. Yes.
My lord would kindly come to 11, paragraph 11 onward.
Yes.
However, Cascade refused to accept the same. Thus, the third respondent issued a show cause notice dated so and so. As per the show cause notice, the so and so called upon the appellant to show cause why the certificate of registration should not be cancelled. The appellant replied to the show cause notice. It is not a case that it did not reply to the case dated so and so, seeking to refute the allegations leveled upon it, and further stated that so and so would not be justified in cancelling its certificate of registration on the above mentioned grounds. Third respondent, without giving any reasons and without giving the appellant any personal hearing, held vide its order dated 19th March 2008 that the registration certificate of the appellant stood cancelled. Being aggrieved by the order, the appellant appealed before the second. Appeal also he exhausted. Now, my lord, appeal order was also not in his favor. Now, my lord, 16. What he challenges, my lord, at least, my lord, what is recorded, he did not challenge the show cause. First authorities order, then para 16. Being aggrieved by the order dated 19th March, which is the order of the authority concerned, 19th March, and the subsequent appellate order is 20th June. 19th August. That is 19th August, madam. The appellant preferred a writ petition before the Honorable High Court. The High Court found no error of law on the face of record and upheld the findings of the appellate authority and dismissed the writ petition by an order dated so and so. Now 22.
Yes.
But this was the submissions that reached definite conclusion about the alleged guilt before the appellant. But 28.
Yes.
It is no doubt true at the stage of show cause, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at that stage, the authority issuing the charge sheet cannot, instead of telling him the charge, confront him with the definite conclusion of his alleged guilt. If it is done, as has been done in the instant case, the entire proceedings initiated by the show cause gets vitiated by unfairness and bias, and subsequent proceedings became idle formality. Now 37 months. Appellant gave a reply to the show cause, but in the order of the third respondent by which the registration certificate was cancelled, no reference was made to the reply, except saying that it is not satisfactory. The cancellation order is not. So this was also weighed in the mind that there was no response or there was no consideration at the time of issuance of the show cause. Well, Oryx is not a judge or is not a ratio. Simplicity that I have prejudged the issues. Well, I have to give some response to his answer. Now he has basically widened the scope by giving a reply of full-fledged and putting all its cards before the authorities. Now, my lord, if I have to satisfy, there has to be objective satisfaction to or a subjective. That my lord has to decide. But there has to be certain satisfaction on the level of the officer concerned before issuing a show cause notice. And that is what I have done pursuant to the direction of the division bench. 31 is also there, my lord. If my lord sees paragraph 31, it is of course true that the show cause notice cannot be read hyper-technical and is well said that it has to be read reasonably. But this is also one of the considerations. But entirety of the thing has to be done. But there is a specific statute, and that's why I have relied upon the Justice Lalit judgment. It was also dealing with a particular statute, and the show cause notice flowed from that statute. And the show cause notice from that statute. That's why the statute says it's a complete code. You have your protection at every stages. At every stages. At every stages. When it's just not, you are not jump out of the one stage and directly come to court at every hat. No, drop of the hat. Now, my lord, is another judgment my learned friend had relied upon. Allahabad judgment. 388, right? 388. Did I put it?
No, I think he had relied on Siemens.
Siemens.
There are several annexed, but he had placed
Siemens.
two. Siemens and this one.
On the context of prejudging, only these two.
Yes, predetermined money.
Lordships.
Allahabad, and why is this?
Allahabad, Lordship, was for 226 Bharat Mints.
Relied upon. That's why.
No, I had not placed those.
We
It
had
was in the once.
There in the petition.
Like, this was
391. Malad, kindly see 3 and 4. 4, Malad. The 3, appellant is a multi-location company. It has a factory.
Which one?
Of 391 Siemens.
391. Yes.
It says for the goods supplied from the said factory in terms of the provisions of the Bombay Provisional Municipal Corporation Act. It also owns a factory at so and so, its office at so and so, the said factory at so and so, and the office at or outside the jurisdiction of the city limits of Navi Mumbai, and thus outside the territorial jurisdiction of the supplies are made to the dealers directly from the appellant's factory situated in so an office. However, the establishment of the appellant at so and so was directed to pay taxes. But there was a direct demand there. There was no opportunity, giving opportunity to pay taxes, although according to it, no jurisdictional facts exist therefore. The demand was made terming the same as a show cause. It appears that in course of some vendors have made certain complaints as regard to the transaction of goods from the appellant's factory at Kalwa. The appellant made its representation on receipt of the said purported demand. Oral and written submissions were also made by on Atto and Atto, stating that the appellant had neither been receiving any goods within the local limits, so and so. Now, my lord, 7. There was an affidavit filed before the after 6, writ petition did not hear out the matter, did not entertain. 7, my lord, there was a direction for affidavit. Writ petition, क्या बोला? Order.
Yes, I've read it.
Challenge to the 7, my lord. Here, this was the state, an affidavit was asked for. Here, the officer said, yes, we are confirmed. Well, here is the case of demand, direct demand. If says, well, that was the consideration. Purported show is directed to payment. 5 also minus C's. By the reasons of the purported show cause, the appellant was directed to make payment of cess. So, my lord, no opportunity was given to the concerned person.
No, but it records that you are requested to attend at the above address on such.
Yes,
such
but
period.
there was already a finding. You have to make the payment. But that was the consideration, subject to correction. One. Now, paragraph 10, ultimate finding. A bare perusal of the impugned, order impugned before the Honorable High Court, as also the statements before us in the counter affidavit filed by the respondents, we are satisfied that statutory authority has already applied its mind and has formed an opinion as regards the liability or otherwise of the appellant. If in passing the order, the respondent has already determined the liability of the appellant, only question which remains for its consideration is quantification thereof. The same does not remain in the realm of a show cause notice. But that is absolutely different. Today it's a self-assessed tax regime, GST. He has self-assessed and has taken some benefits, which I found is not correct. Under the law, my lord, I have to give him, this is according to me, this he were not entitled. I have given him the information at the stage of pre-show cause, intimated him as per the language of 74 or 73, whatever the pre-intimation. Thereafter, I have issued a show cause notice upon considering all his facts. But this judgment does not consider a fact where there is an order to consider the or give a finding to his allegations or to his reply.
case.
Today, my lord, kindly, my lord, don't my lord, take me otherwise. My lord, I cannot be held guilty for first for not considering, and thereafter, after considering, I have been told that I have prejudged the issue. But for both head and tail, I cannot use. I always use that word. But I have, for the first round, I was alleged that I did not consider. I lost. When I considered, he comes and it's a prejudged issue. Where I go, my lord, I consider it's a finding. He has invited the court to the authority to give a finding.
Lordship, I will wait for this 10th November matter to be heard by the Supreme Court. Then maybe in some new case, I'll bring that.
Roshan, if I'm not wrong, I had appeared in division. Well, a division means not passing an order in favor of assessing doesn't happen much. But this is my submissions.
Yes, Mr. Kanodi.
And the suppression it's a case of collusion. When the moment I say you have transaction with a non-existent person who had never done any business from his place of address or the address.
No, but that
mentioned
can be a case of fraud. How suppression?
Well,
What?
it can be, he has suppressed these facts. But it can be a case of fraud also. But the authorities have also mentioned fraud. It is not the only suppression. For fraud, collusions. But fraud.
Section 74 has all of this.
All of this. When Contract Act, fraud is defined in the Contract Act. If I take a leaf from that book, Contract Act, what are the ingredients of fraud? Knowingly, he has shown these papers to me. Knowingly that they never existed, he has shown these papers. But we, at the time of
No, but the GST of that of his sellers, of his vendors, those were uploaded by them. What
Well,
control has he got on them?
Well, now I
Because that is one point which has been troubling
well, I
courts all
come to
over.
that. Well, I come
That
to-
if today a person is registered, and I enter into business transactions with the person, I continue for some time. I'm not obliged to continue with him for the next decade. I switch over to a different person, which I'm entitled to in my business in law also. Now, after 2 years or after 3 years from now, you for some reason find something against him and you retrospectively cancel it, such that cancel his registration, such that my business or the period during which I have conducted business with him also falls within the domain of his being registered, and then you charge me with having entered into business transaction with him, saying that it has been you have conducted business with a person who is non-existent. How do I know that in
Well,
future it is going to be cancelled?
may I try to answer it. My lord has used two expression for any reasons I cancel it. So it cannot be for any subject to correction. But I have
For any reason mean any reason
But
which
I
is
have
adumbrated
found-
in law. That is what I meant.
Tender apology, madam. I have found the concerned person had never done any business. It was just a minute. In many cases, we have found we are supplying goods to a person, and his office is 100 square feet. The goods could not have been stored there. Goods could not have been stored. Never could have been stored. This 100 square feet or 50 square feet. Hardly one person can sit on this chair. But this would require a full-fledged investigation. But one part of the investigation is over. The supplier has been found to be non-existent. I do not know whether the challenge has been thrown with cancellation of registration. It has been found that they have never done any business from that place. So whoever is the other party is a collusion matter. It's a case of classic collusion. But if he has, I am having an office and I'm not doing, I do not have the infrastructure to have so much loads or too much supply. But can the authority?
Have you said so in the show cause notice?
Well, it is there, man. Kindly see show cause notice.
Yes. Because as a report, I will definitely not go into this. I will be cautious enough to keep my decision only as to whether I should entertain or I should not entertain. The factual findings, I am not going to conclude whether there is collusion or not.
Yes, but that has.
But I have to see whether notice could have been issued or not, and now that will be sustained whether the notice is rightly issued or not issued. That will be tested by the adjudicating authority and the appellate authority. At the stage of a writ being entertained, I only have to be satisfied whether he had jurisdiction to issue or not. If it is an error within jurisdiction, I will wash off my hands by way of a writ. I'll say no, it is an error within jurisdiction. It
Will not.
should not be. That's it. Because I have been pounded by almost a dozen of authorities by both of you now. So yes,
My lord,
page
my lord, I'd come 370 I had shown, my lord.
370.
Yes, my lord, I had shown just. My lord, serial 3. With regard to your submission as noted in serial number 3, it is to state that the supplies were cancelled under section so and so as they were found non-existent or a registration has been obtained by means of fraud, willful misstatement and suppression of facts. The ITC chain prima facie also points that the firms were created intending to carry out fraudulent and devious practices of receiving, issuing tax invoices without having any existence or functional activity and without entering into actual business transaction to accumulate input tax credit and transferring the integrated them the same without actual purchase, sale, movement of goods or delivery and receiving of goods. Hence, prima facie it appears that these firms integrated themselves in the chain and were passing on the credit first to different other fake firms and then ultimately to one actual business firm after many layers which seems synonymous to concept of placement, layering and integration as is money laundering. It is not that minute I have not said something. There are other things also I have said, but I can go on saying that. But there are ingredients. There are ingredients. Prima facie, there are ingredients. And I'm grateful, Madam, for giving this opportunity.
Yes, Mr. Kanuri.
Lordships, on this, two judgments of Siemens and Oryx Fisheries which my learned friend relied.
No,
For-
I did not rely.
which he count distinguished Lordships. In Siemens, Lordships, it was a case wherein a show cause was issued in the nature of demand.
Show cause
It was
was
not a demand order directly.
Right.
It was a show cause which
I'm
the
not-
court held to be demand. That is the only distinction. And Oryx Fisheries, why I relied upon Lordships, was very specific for para 28 only. The jurisprudence laid down by the court as to while reading a show cause what should come out. Only that paragraph was my reliance. What the court
That it was issued.
It
with a
is no
predetermined
doubt.
mindset.
The person proceeded against must be told the charges against him so that he can take his defense and prove. It is obvious that at this stage the authority issuing the charge sheet cannot, instead of telling him the charges, confirm him with definite conclusions of his allegation. This is only the portion which the Supreme Court had narrated. I have relied upon this in the facts of the present case because on perusal of the show cause notice when I have given a
That is the
reply,
first impression.
that is the first impression. That is my only, nothing more.
I'll pass my orders because today Thank you. Thank
Yes. Yellow. Yes.
My lord, on the previous occasion, my learned senior sought time to seek instructions in the matter. And therefore, the appeal that I preferred was not barred by limitation. And my lord, also
But
that,
is it not that when you upload the order, you have to digitally sign it or something is there, no?
my lord, in this case, no detailed order was uploaded. Only the summary DRC 07 was uploaded.
But there are two aspects in the matter. One are allegation as regard to the detailed order, whether it was uploaded or not. I have got a parawise instruction where it says has issued a detailed order, but I have not seen it. So
No,
I,
but I have seen in the writ petition, I have it it marked here. A specific allegation is that the order was uploaded on the portal only on 25th of August, and on 28th August he has filed the appeal. So that way appeal is within time,
yes, there is another aspect.
because when it was uploaded in the portal, that can be best known by the authorities only. He will not be able to know when it was uploaded.
Kindly remand the matter back to the appellate and allow him to file. And there is one development, Malak. Wrongly, the authorities for the same period on the same issue had issued another DRC 07. Now, Malak, they have rectified it and they have issued a rectification order withdrawing such.
So very well, that is not required.
Because he has annexed that thing, so Malak, it may be on record 14 November, it has been rectified. So the next show cause he is protected to that. 14 November, it was withdrawn.
I'll record this. And so far is delay.
Milord, by this writ petition, Milord, I have challenged and ordered an appeal dated 24th July 2025, Milord, on Milord, on the ground that there is no alternative remedy, and on the ground also that Milord, there was a delay in preferring an appeal before the first appellate authority of 551 days.
551 days.
551 days, Milord.
That's a bit too much.
Milord, two reasons I had given in my I had filed a condonation of delay application relying on SK Chakrabarty's old judgment saying that Limitation Act can. So two reasons, Milord, which is on record, Milord, I had given. First is that, Milord, the phone number that we provided as part of our GST registration for receiving and sending SMSs for getting update of information which is being uploaded on the portal, that was defunct, that was not functional. One. And the second reason, Milord, that I have mentioned in my application was that this order in original that we had challenged was uploaded in additional notices and orders as opposed to notices and orders. That's why we did not see the portal. Once we were doing a review of our own portal, what is uploaded, what is not uploaded, Milord, in month of May 2025, Milord, we came across this order in original. We filed an appeal, Milord, along with payment of pre-deposit. Milord, in this case, I'll accept that the appellate authority, Milord, has gone into the merits of my delay application and come to the conclusion that I have not been able to show sufficient cause. Milord, but apart from that, Milord, the appellate authority has restrained himself from discussing on merits. Milord, merits, I have filed a reply to the show cause, but Milord, I was not granted a personal hearing.
But 500 days delay?
551 days, Milord, delay.
551 days delay is a bit too much.
Because, Milord, what is balancing in my favor, Milord, this is against me, and this makes the other side heavier. But, Milord, what is balancing in my favor, what I understand is, Milord, the issue, the demand of tax is 5,17,000. It is divided into three broad issues, Milord. And on those broad issues, Milord, all on technicality, Milord, all of them will be in my favor. If I have a patient a year lended by the adjudicating authority or the appellate authority, Milord, I am certain, because this is a case under section 73, where there is no intent to...
Where is the application for condonation of delay?
Milord, my application is on page 73.
Just one information. I am not sure whether it is being done for all cases. Whenever there is some issue, show cause notice or issue, there is an alert notice is given through mobile. It is given most of the cases. Because of the officers, I don't know whether they do not tell us, so we get, but most of the cases this is done.
Milaj, by the explanation to this is in paragraph 2. Milaj, I had mentioned also, Milaj, the phone number, the mobile phone number that I had given at the time of registration, that had become defunct. That was not accessible. So, Milaj, if I have received, I'm not saying I have received or not received, because I cannot comment on that. But, Milaj, if there was also receipt on that number, I am not come to knowledge.
Is it not your obligation to update the correct mobile number on the with the authorities?
It is, Milaj.
Then in that case, you cannot find fault with that. Whatever record you have produced, they
Yes,
will be obliged to send it on because they don't have any means to know what other thing has happened in.
Yes, ma'am.
So,
Milaj, this argument, I do not use it as a spear. I use it as a shield only, Milaj. I am not saying that I am asserting it, but it is Milaj, a very...
because if your argument is that the mobile had gone defunct or
yes,
for some reason the number was not working, then in that case it was your responsibility or
it is
your duty to inform the authority that this is not the number, This is the updated number on which you please send. If you change the address,
Yes, my lords.
then you cannot fault the authority with
Absolutely not.
serving on the address that is recorded.
Absolutely not.
They will have only knowledge about that.
Yes, my lords. That's why, my lords, I've just come.
Additional notices. So in all these 5 years,
Yes, my lords.
no, sorry,
551
three
days.
and a half, two and a half
Two.
years, maybe or around 2 years, around 2 years. You did not receive any notice, any order.
No notice. My lords, there was order in original was already uploaded in additional notices and orders. I did not receive any recovery.
The question is whether all the notices and orders are uploaded on additional notices and orders in that tab, or only some.
My lords,
Saying it ought to be in the additional.
my lords,
It ought to have been in the additional, you want to say?
no, I'm not saying it ought to have been. I am only saying that for multi-reach, there is another writ petition, my lords, same cause of action. Over there, it was not additional. So it's not in all cases, it is in additional notices and orders.
Okay.
It was that it has happened.
In this case, it was in the additional.
It was in additional notices and orders. It was skipped.
Additional notices and orders tab, if it is there, then
Milad,
definitely it is going to evade somebody's notice.
And it has, Milads, come across this issue, Milads, is not that is risen today or only in my case, Milads. I have a series of judgments, Milads, of our High Court only on a single bench, Milads, which says that this is a fault that has occurred. Milads, they have condoned delay, or they have allowed me. Just Milads, this judgment of Shukumar Kundu, and Milads, this judgment of Mohammed Hasim Khan.
Yes, that should form good ground, because
Yes.
if it is at a place where a person would normally not look into, that will not amount to good service. Service should be service, proper service. It is like serving someone else's notice to somebody else.
Milads, these judgments have not gone till the extent and said that this is not amounting to proper service, but it has understood the problem and come to that they have remanded the matters. That is the conclusion of both these judgments. The second judgment I show of Mohammed Hasim Khan, Milads, over there, the petitioner was not able to show that there was sufficient cause. Even in those circumstances, understanding the situation, Milad, this honorable court had fairly remanded the matter back to the authorities, Milad.
Actually, there is a distinction. He has replied to the show. So he was aware of the starting point of it. It is not a case that he was not aware of the proceedings. He had replied to the show cause. He contemporaneously has replied to the show cause.
That show cause notice was uploaded where? Additional.
Milad, that I have to check. I have not pleaded that particular fact where it was that uploaded, because orders I have pleaded.
Of the starting of
proceedings. So Mr. Chakravarti is.
I can understand, Manad. I can understand, Manad. But today, Manad, actually, Manad, this is a new case. Manad, here is a case who were aware of the initiation.
You want to file an opposition to this?
Letter. You could have written a
You use an opposition to this then, unnecessarily, because without opposition, you use.
Yes, we have to also take instruction whether the show cause notice was issued. But I can, affidavit will not help him. I'll come with the instruction on this.
Milad, one small thing before we part, Milad. My learned friend said that these are distinguishable on facts, Milad. That's why I gave this judgment of Mohammed Hasim Khan. I'll just bring your lordship's attention to one sentence. Milad's paragraph 5. Over there, Milad, I had mentioned that the court did not find any sufficient cause. It is written the last line. However, having regard to the facts of the petition, facts that the petitioner had responded to the pre-show cause notice, I am not inclined to accept such explanation provided by the petitioner that I am not aware of the proceedings. Similar. Over here, instead of pre-show cause, I have replied to the show cause. Milad, and I have not replied to the pre-show cause notice. Subsequently, in paragraph 5, Milad, the bench has said, be it as it may. Milad, I remanded. And Milad, they imposed a certain amount of cost and remanded the matter, Milad. Because this is, I am not causing any prejudice to the revenue, because these are proceedings under 73.
This serves the purpose.
Okay.
This is almost similar.
Sorry, I do not approve this.
We can. No, this order is applicable on all fours. Full stop. List this matter. इनके दिन 13 तो टाइम चाहिए 12 दीदी लिखे नहीं
My lord, might recall, but this is the matter where the
change of opinion
yes, no, the assessment here 1819 note it was reopened note and they accepted, and 1920 the transporters assessment also note was had been done, and not the because my learned friend was going to make submission. Note one aspect is that in the hands of the transporter there was no the order did not speak of anything, because not if the amount was not referable to any business conducted, then it would have been assessed under the head other sources under section 68 not as an unexplained credit, and the taxation would have been under section 115 BBE, which is 60%. So my lord has seen that in the matter yesterday, the other day, where they said it is not sale proceeds of goods, it is accommodation entry. Because I would have returned it under the head business.
yes
So if it is
because
not
you on the last occasion took me through the assessment order which was passed in the first round of the notice
for
of
the
reopening
yes, but for the
same assessment here in respect of the petitioner itself.
Not the I had placed before my lord the assessment of the transporter, not for the assessment in 19.
And page 155 is of the petitioner.
Yes,
assessment.
155 of the petitioner for assessment is 1890.
1890.
Ours is 1920.
This is 1920.
And what I had also placed the transporter's assessment for 1920. Where not this precise amount is
But 1819 was also based on the same.
same. My lord was actually comparing the notice there, 148 notice and 148
Yes.
the information, it was identical. The documents, the statement, everything lord was identical.
So this assessment order also nothing was found in 1819. The assessment order was on the basis of whatever you had earlier.
Yes, that I had incurred that expense.
143 was so this assessment order was nothing punitive in the sense.
No, my lord. And this was the only allegation for reopening was this, that according to documents impounded at the premises of the transporter and statement of one of the directors, this you have received so much of cash back. I paid not several crores of rupees because they're transporting the raw materials, which are
Only change which is here is the year, assessment year.
and the amount. My lord.
And the amount, it's 80 lakh something here, and it was 4 crore
My lord.
in the earlier round.
Lordship. And not not in case authority is needed, no, there are two decisions of our court, not where not the assessment for an earlier year was made accepting a particular stand. The assessment for the subsequent year not was under 143(1). There was no, so not, nevertheless, not the court was pleased to accept the submission that it's a case of change of opinion because the year you've examined it and thereafter in the next year you have.
Because opinion is to be formed on the basis of material, not the year.
Lordship.
Now, unless you have a fresh material in respect of the subsequent year or the succeeding year, that will definitely be change of opinion.
Lordship.
Opinion will not change if the basis is changed.
Lordship.
If the basis remains the same, then whatever year it is, opinion is same.
Lordship. Whether here not it is flowing from the same survey, same the documents, everything.
That is why I was on the last occasion comparing it, as because the language also I found it to be starkly similar.
They just know the paragraph numbers have become different because there it was all.
The chart is missing.
Yes.
Yes, Mr. Dotto.
My lord will kindly take Miller page 155. Page 155, which is P15, which is an assessment order for the year 2018-19. Kindly take.
Yes, there, 155.
Millard, if I may be, it's a very short order. If I may permit to Millard read it. The SSC company filed its original return of income under section 139(1) of the assessment year 2018 and 19 on 30th November 2018, declaring a total income of nil under normal provision and 3 crore 56 lakhs, 356 crores 57 lakhs book profit under 115 JB of Income Tax Act. I'm not used to reading so large a figure.
I'm also not used.
The assessment was completed on 10th of March 2001.
So I don't use that crore and all this. I go by comma and figures. That is easier.
Millard,
3 comma 56 comma 57 comma.
I was unable to Millard, do that also.
That ensures that I am not incorrect and I don't muddle up with figure. I mean the expressions lakh, crore and all. So that is the safest way.
So 356 crores 57 lakhs. Now, Millard, the information regarding the transaction of Mrs. Himadri Chemicals Limited with Mrs. Liquid Carrier Gold received from Inside Portal. Accordingly, a show cause notice was issued on 21st of March 2022 under section 148 AB of the Income Tax Act with the prior approval of the principal CIT, Kolkata, and the assessee was requested to submit the explanation. In response to the show cause, no reply was submitted by the assessee. Thereafter, an order under 148 AD of the Income Tax Act was passed on 30th March, and the principal prior approval of the land PCIT. and a notice under 148 was issued on 30th March 2022. In response to the 148 notice, the SSC electronically filed its return on 30th April 2022. Accordingly, a notice under 143(2)(a) and 142(1) of the Income Tax Act was issued on 25th of May 2022 and served upon the SSC. In response to the notice, the SSC made its submission on 23rd June. Now, Miller, this 23rd June, your lordship will find at page 131. The response of the SSC. In the light of the above, the income is calculated like this. Now, Miller, the first income as per 143(3) dated 10th of March 2021, that your lordship will find at page 82.
Page 80?
82. Page 82 is that particular assessment order which was passed prior to passing of this order.
Yes, this is under 143(3).
Yes.
It's a scrutiny assessment.
Now, Miller, kindly come to page 181. This was for 2018-19 and this is for 2019-20.
Yes.
The subsequent assessment order. Now here, Miller, your lordship will see. I'm reading from the second paragraph, Miller. In the instant case, a survey operation was conducted on 9th of April 21 at the office premises of the SSC. This was for liquid gold. Now, my lord, kindly take page 186, which is in the case of the SSC. Now, Miller, your lordship has seen from the assessment order which I had placed before you of 1819, there the allegation was made, but there was no inquiry on the allegations made. It was simply on Insight portal. This is appearing, and therefore a notice was sent to them, to which they did not reply. And
no, why do you say there was no inquiry?
There was no inquiry because the assessment order does not say so. The assessment order which I had placed at page
155.
155, yes. 155.
Why do you say there was no inquiry?
Because there was no inquiry, because it does not say so. This does reflect from the assessment order. Kindly see that information regarding the transaction of Himadri Chemicals and Industries with liquid gold carriers received from Insight portal.
No, but this has to be read along with the show cause notice.
Accordingly, a show cause notice was issued on 21st.
This show cause notice is at which page? Show cause notice was there because on the last occasion I had seen the show cause notice. I had compared it with the one issued now. The show cause notice is at page
Miller 92.
Page 83.
93.
93. Page 93. See, the show cause notice, if you compare it with the show cause notice now issued,
yes,
page 167.
Yes. But these show cause notice, they did not reply.
Yes, but they have ultimately replied on
to the new show cause notice. And the reply,
No, not to the show cause notice. Maybe they have not replied to, but on the last occasion, Mr. Khetan placed the reply to the show cause, which might not have been considered, but they have subsequently made a written submission on that is recorded in the order. The assessment order records, which you just now showed, page 131.
now Miller, what I'm on
Page 131, I think is this must be the same as the reply, because page 131. This is in reply to 143.2 notice. Where is that notice? Page 116. 116. 116. Yes, if you see page 116, it has an annexure. So this annexure, if you compare it with the show cause, it will again tally. So the answer to this was in fact an answer to the show cause.
with that transit made, my lord. Kindly see that the assessing officer did not specifically deal with the contention of the show cause in this assessment order. Miller, thereafter, in the new proceedings, the assessment was again considered.
Assessing officer, according to you, has not adverted to the content of the show cause here.
Yes.
So therefore, there is no
In
inquiry.
the assessment order. At least it appears from the assessment order.
Very well. Yes.
Now, Millard, kindly take page 186.
Page 186.
Where the assessing officer has gone into the details of the transaction and also has referred to various cross-examinations of the witnesses and the documents seized during the search and seizure operation, and has come to page 193, which is section paragraph 6.2, 6.3, 6.4 and 6.5. That is the conclusion.
Yes.
Now, my lord, in this assessment here, much different from the prior assessment here. The prior assessment here, this issue came up, but in this assessment here, it has been gone in, and the assessing officer has referred to all the details of the transactions between the assessee and that liquid gold.
Yes.
Now, Millard, I have a judgment of this Honorable Court of Division Bench, which says that if an assessing officer has not gone into details in an assessment proceedings with regard to an particular allegation, then in that case, it shall not be deemed that he is reappreciating the evidence. Or there is a change of opinion. Kindly see, my lord, this, because in the first assessment order, the opinion has not yet been formed. In the second assessment,
How can you say opinion was not formed? Because he has formed an opinion of sticking to the earlier assessment. That's it.
yes,
Whatever was assessed earlier, he has not changed it. The return filed by the SSC has been accepted as it is.
as it,
Yes.
but
So he has
subsequent-
therefore, he has not found favor with the adverse prima facie finding that he had indicated to him in the written notice. I mean, in the show cause notice.
That is so. But in the assessment order, it is not reflected that he has taken into consideration.
But Mr. Dutt, it can be implied, it can be implicit. Texpan, CIT versus Texpan.
Well,
It can be implicit also, it can be, if
My
it is
lord,
not either
kindly-
implicitly or
Can we
yes,
have
yes,
a look
please.
at this order, please? Because I know my limitations in this matter. Paragraph 18. ma'am.
This was a scrutiny order, 143(3) order. This was a scrutiny order. Scrutiny order will not have that expansive scope of inquiry which will be there in the assessment order passed under 147 on reopening. The second one was an assessment order. Yes, that's always the law, that for the change of opinion, there has to be an opinion.
Yes.
There was no formation of opinion.
Now, in the first, in 2018-19, in my submission,
There was no opinion.
there was no opinion. And in subsequent years, there was formation of opinion. So therefore, there is no change of opinion.
Right.
এখানে তো চেঞ্জ অফ ওপিনিয়নে মামলা করেছি মানে in my submission the writ petition is in a premature stage because in this writ petition the petitioner has assailed something which has not yet reached the final. It may be so that after considering his reply and considering all the aspects of the matter, the assessing officer can drop the proceedings against him. We cannot rush to the conclusion that, my lord, the assessing officer is going to pass an order against him in spite of his representations made before the assessing officer and also prior representations. And my lord, this is not a fit case where the writ court should interfere at this premature stage. That's the last
Yes.
Corporation says that when the report can interfere. And now that this is an act, that act itself will have giving without the efficacious similar remedy to the SSC and it has step by step adjudication. Now that we have 140 step to scope of stage. Scope of not an exceptional case that there is no SSC did not say that the violation of principle national justice. SSC did not say there are jurisdiction because the assessing officer itself had not having the jurisdiction not interfering in the issue. It not says that is taken illegally. Only it's
Change of opinion is error of jurisdiction.
change of opinion. It says when we are saying that we are in the earlier assessment order, maybe there is a material, but the assessing officer did not form the opinion.
That is your
Now
contention.
it is very preliminary stage. Our the court will interfere in the stage, then the statute itself will have trusted. Now following the powerful corporation, our single with moral justice, it says that we are out and thereafter we are handed over. Will settle that the court do not interfere in cases where statutory remedies are available unless there is a clear violation of fundamental right, lack of jurisdiction or procedural perversity, leading to the manifest injustice. The petitioner has not demonstrated any such exceptional circumstance warranted in this court intervention. Instead, the statutory framework under GST, but same principle under GST Act provide adequate mechanism for addressing the petitioner's concern. Now that Abdul knows after 148, will be 148 2 notice, 143 2 notice, so called thereafter access. It is a very premature step to say that it is a change of opinion. Like the faceless authority will not have the power if the assessee says the change of opinion and he can address the issue and therefore assessment may be dropped. It is not that the 140 notice has been issued, therefore assessment has to be fast. But you also can see this judgment.
There is.
Paragraph 27. And what I have not got the judgment, I have my mistake. You also kindly knows that Ansul Join. These two are up to Supreme Court. The Ansul Join also case say that the initial when 148 AD order was now 148 very preliminary stage and preliminary opinion has been formed.
Anshul Jain's case.
Several chapters of different high court, Punjab Haryana High Court, Telangana High Court, even
Anshul Jain was not a case of change of opinion.
No, it says not change of opinion, it says
change of opinion is a jurisdictional point.
When but it is not my submission to lordship is not a duty of the lead court to see that whether it is change of opinion or not. Because it is very much factual thing. Factual thing like this. Not in this stage, it is a starting of a proceedings. And after 140 up to 148 is the notice stage. The lead court must when we are interfere in legal proceedings, but by the submission that lead court must look into the basic principles.
Yes, so many points.
But they basically were 2 points my learned friends have made. One is that there was no inquiry for the assessment year 2018-19 because there's no discussion or the orders.
Three basic points. One is this inquiry. One is this change of year. It was 18-19. This is 19-20. Then other points raised by Mr. Bhattacharya that there is no jurisdictional issue involved. So writ court should not intervene at 148 stage because it is in the nature of show cause, and writ court is loath to interdict a show cause notice.
But the 148, section 148 notice is a jurisdictional notice. It's not a mere show cause notice. But the 148 A, D, A, B, that's the show cause notice. No, this is not a jurisdictional. This is a jurisdictional notice. Therefore, this is the stage where the writ court can be approached because jurisdiction is being assumed. Now, it is not a premature stage because the officer has not issued the notice under 148.
So he has assumed jurisdiction which he could not have assumed.
No, I'm grateful. No, that is my submission. Now, with regard to there's no discussion or no formation of opinion. There's one important aspect my learned friend has not perhaps he has forgotten that submission of mine, but that on the same day the assessment of the transport company was made for the assessment in 2019-20. On 26th August 2022, page 73 is the order in the transport company's case, and I had also placed before my lord the 142.1 notice issued to the transporter, the 133.6 notice issued to me, the replies filed, and then so therefore the entire matter was before the officer. It is not. It cannot.
Same officer was doing it.
Not the same officer. In fact, the same officer has done both the assessments on the same day. So therefore, when that is the crux of the assessment proceedings, this allegation regarding cash, a specific notice is issued to the transporter, 133.6 is issued to me. My other assessment year, 2018-19, because they're covering several years on the basis of the same material. So because of the commonality of the material, their 1920, my 18-19, both were being conducted together during the same time period. The officer could see the material in both the cases, identical material being used. Of course, the material was seized from the other, impounded from the other person, not from me. Statement was of the other person. So therefore, just because the order does not discuss, but when this is the very subject matter, and my case was a 148 reopening case, and this was the ground for the reopening. Now, to say that the officer has not considered it, or there is no formation of opinion in my submission, it cannot be the revenue stand at all, because he's referring to a show cause notice, he's referring to my reply, and then he says in view of this, which means that he's accepting my reply. He has not rejected it, because he's accepting, therefore he did not have to write a lengthy order. And that is a given in every case. But the officer is making whoever reads the order aware that these are the prior proceedings. There was a show cause notice, there was a reply, the 143.2, the response to that, and then in view of that, now I'm staying with my previous orders. Therefore, it is not a case where there is no formation of opinion, no discussion. I did not cite any authority on that, but the
TechSpan is the CIT versus TechSpan is the
yes, and that
2018 SCCL.
Yes, and
it can be implicit and it can be express.
Logic.
If it is neither implicit nor express, like scrutiny assessment, it's absolutely cryptic, then there is no opinion.
Yes.
Then this kicks in.
Yes. I'm not that Mariko's case, it traveled up to the Honorable Supreme Court, Bombay High Court, where there was this query raised, answer given. And the answer was not rejected. There was no addition in the assessment. And Supreme Court extracted that the paragraph from the Bombay High Court judgment and held that in view of this, no interference was called. But this is that the Bombay High Court and this.
Didi.
But the Supreme Court order is brief note, the second page note, they have extracted paragraph 12. And with the Bombay High Court judgment, the last page, those paragraphs 11 and 12 of the the decisions, West Bengal fisheries, it was a case of a regular 143.3, where
Yes,
there's total omission to. My lord has already
143
seen that.
Scrutiny, so no scope of this broad inquiry as here.
Yes, ma'am. And not in the case in the Sham Sundar Dhanuka, there's no prior adjudication. What makes the difference is the prior adjudication.
Opinion.
Yes.
What about the year?
Not
1919,
as I submitted, not that there are two decisions of our court, not where the cases were reopened, and the reopening was covering not the 143.3 as also 143.1, and not our court was pleased to hold that when you have considered it in 1 year, the next year you have done scrutiny is still a case of change of opinion. Next year you have done 143.1. Because having examined it in
this case, next year, what has happened? Scrutiny of
not
1920?
1920 is not 2021 scrutiny assessment, there is no addition.
And in 1920, the one which is under consideration in this 148?
No, 1920, there's an original 143.1 they accepted. 143.1, the return was accepted. There was no 143.3. Therefore, I made the submission that in a case where in the original for the preceding year there was a 143.3 scrutiny assessment,
and
next year next year there was 143.1. The 143 notice was within 4 years. Yeah, the case which was completed under 143.1.
So you are bringing that logic. Now I understand.
Yes.
So in respect of 1819, there was a scrutiny assessment as well as
A reassessment.
A reassessment. And in case of 1920, there was a normal 143.1.
143.
Therefore, by going by the
Yes.
division bench, this also would mean a change of opinion if you again seek to reopen this 143.1.
Yes, yes. Because
Is your submission.
yes, not the same facts, not the same controversy. If I may.
You have that judgment?
Yes, it's of the writ court, not. Kindly first, there are two decisions. Kindly have. Kindly take paragraph 1 at page 157. That will show the different years involved. But from assessment in 1991 to 1996-97. And then paragraph 38 at page 168.
Yes.
Look at page 168, paragraph 38.
Reasons are same and facts are identical.
It was treated as a case of change of opinion. And what this was a subsequent decision by the same, this was followed and with same view was taken. If my lord is pleased to have paragraph 1 at page 188, the assessment years are mentioned 98-99 to 2001-2. Those are the 4 years for which reassessment proceedings were taken. And with paragraph 15 at page 191. Look at paragraph 11 and then look 15. 11 at page 190 and then
Yes. Last 3 lines of paragraph 15.
Manoj.
When all the necessary information was before the assessing officer in the earlier assessments, reopening under such and such amounted to change.
Because not all the years were not scrutiny assessments. Not, therefore, not if the because the facts here are such not that I'm able to make this argument. If the facts did not support this argument, not,
Yes, yes. Then in that case, it would. Then there would be no opinion on those facts. Opinion has to be on facts.
absolutely.
I'll pass orders because now it's 120.
Gotcha.
So there'll be defect of jurisdiction.
Gotcha.
লিখে নিন কি করি পরে দিয়েছি ফালতু বসে দেরি করে লাভ নেই
what has transpired. Is well aware that there are two tabs on the common portal.
Additional thing.
And notices in this case, what the authorities have done is that they have uploaded the pre-show as well as the show call on the additional tab. In the order, they are in isolated manner uploaded on the notices and order. This the difficulty the petitioner has faced, slightly comes to page 47.
Where is the other side? That is there, but that should be there. I'm making it not today, tomorrow they may appear. Not today, Karvi. $14 you are appearing?
No,
Watch. Deal. Why? Delay.
They have that against a temporary contract. They have done a new contract right at the end of the
How many days delay is there? 240 beyond 4 months. Yes, Mr. Sanyal.
Lordship, the reason which he has shown at page 55, page 56, due to demise of one close family member of the appellant, he was not in a sound mind to file an appeal in due time, and the same time accountant of the petitioner on whose shoulders the responsibility of the portal related work was vested left the job midway around 2024. Was in December 2024, petitioner was able to concentrate his business, and then his new accountant is between the date of impugned order 2024, now between the date of 7 March 2024 and the filing of the appeal on 4th March, the GSTI portal reflects the appellant filed both GSTR1 and GSTR3B returns for the period from 2023 to 2025. This consistent return filing pattern as well as a steady business turnover also undermines the claim of delayed appeal filing due to petitioner's bad state of mind as well as accountant's resignation from the job.
That I had a part-time job for 25 years.
My job was too.
What is the date of the order?
Date of 24. And the appeal was filed on 4th of March 2025.
Cost.
I'm not standing in his way, but the reasons which he has
Cost.
In the month of April 2021, I voluntarily submitted application for surrendering my registration certificate under the registry. But that application was rejected on a ground that the not produced the cancelled feedback. So Lordship is not a mandatory provision under the Act is my understanding. So Lordship, I can keep my feedback. I can go for any other business which does not accept it. But that was rejected. In April 2021. In October 2021, Lordship, there was a field inquiry, and there nothing was forward to me. I don't have any knowledge. There I was found on it. It is obvious that in April I submitted self-represented letter, so I will not be found in my registered case of business in October. Now thereafter, Lordship, a show cause was issued. Only 2 lines. The Lordship will find in page 13, where registration was obtained by wishful fraud, wishful misstatement, as the Lordship knows the common language. What fraud, what wishful misstatement, what nothing was there. Within 2 days of within not even a month, within less than a month, my registration was cancelled with retrospective effect from the date of grant of registration. Now, Lordship, thereafter I filed an appeal. In the appeal order, Lordship, I came to know that there was a field inquiry because nothing was applied to me. Now, in my humble submission, Lordship, I have applied for surrender of the registered certificate. Let the registration was cancelled, but not from the date with retrospective effect. From the date I have applied, because the department knew very well that I have surrendered that.
Before cancelling it with retrospective effect, you were not given any opportunity to show cause.
No, the show cause was there.
So then you did not take this point.
Come to page 30, show cause was there. I managed that. And the normal language of fraud, which will misstatement, proportion of fact. But no details was there. What kind of fraud, what kind of misstatement, what facts I have suppressed, nothing was there. And then on page 31, show cause was done on 27th of October, and on 21st of November, not even a month, just one line order, fine. And the effective date of cancellation of the registration is 5/2/2020.
Page 30.
Page 31 is the order.
Page 30. Where is your answer to the show cause?
That I could not, sometimes I could not place it. But it's written because in the order document that I find the very first line.
Yes.
These are reference to your reply dated 12/11/2021. So there was a reply. Admittedly, there was a reply written by the officer.
No, but in the next line it is written no reply to the show cause.
Conflict. Officer himself is writing. Where from he is getting the date? It's not 11/11. It's not 13/11. He is giving a particular date 12/11. So far, I understand from this order. So the reply could not be attached. That there must be a reply.
Yes, Mr. Chakravarti. What was his reply that you have considered and not dealt
with? It is possibly the format copy paste.
No, but his reply ought to have been considered then.
Ought to have been.
Okay.
How has the appellate authority dealt with this?
Page 39. Nothing. We are just in the 5th paragraph, the appellate is saying on 25th, 10/2021, SPO JBJ start conducted a field inquiry at the declared place of business or petition to verify the existence of the present activities of the business. In the report stated that we could not find the place of business. But it is obvious that I have already surrendered my name. After the lockdown, the petitioner was suffering from immense financial difficulty.
But before the appellate authority also you have not appeared any day. Why?
Actually, the petitioner has already at that point of time suffering from illness. Document age 42. I have also annexed the medical certificate. Page 43. So it does not appear because the individual is not in a position financially to appoint any professional person. He was not in a position at that point of time. That's why he could not appear.
No, but how many days from January to February? These are all homeopathic medicines, homeopathic doctors' prescription. This will not help. For 1 month, you are under homeopathic treatment, then and it is sunstroke. Sunstroke in January, February is difficult.
No, not in that.
Yes.
March.
What March? The dates on which you did not appear before the appellate authority are 16 January, 24 January, 15 February. You can't have sunstroke then.
No.
Then your prescription shows sunstroke. Diagnosis is sunstroke. Difficult case. You ought to have appeared before the appellate authority. How will I fault the order of the appellate authority? The appellate authority's order cannot be faulted because you did not appear before the appellate authority. Then
He could not appoint any professional person.
Then so he was, and there is no explanation why you did not.
On the favor. Since Dr. There was a copy order itself. Now, the matter is remanded back to the appellate.
On what ground? What do I say? How do I say that the appellate authority is wrong? On what basis will I say that the appellate authority is wrong? You give me some handle that yes, appellate authority is wrong because you have not appeared before the appellate authority. You have not submitted any document.
No, that I cannot improve the fact.
That is the problem. I have to.
May I help him? May I help him? My lord, there is a division bench judgment presided over by Justice Shivagana. I am not having it today, which says a show cause notice for retrospective cancellation. You have to specify the mention of that. I don't think in the show cause notice it is mentioned.
No, nothing is mentioned.
अरे दादा तुम्हारे
I have.
Huh?
You have that judgment.
I am not having it. My lord.
But here it says it is willful.
Willful, but that was the my lord, I lost it, but it was directed suo motu proceeding should be started. There, my lord, there was no office. Absolutely, when the visit officer came, my lord, they were pasting the signboard. But that is in his favor. You can remand back the matter before the because ultimately it's the cancellation of registration. Today he has come because master suppliers of master pressurized him.
When did you apply for cancellation of your registration? Where is that?
Case 27, answer 63. Answer case 27. Date of filing 6/4/2021. First point.
This is 6th of April 2024. 21.
And as per the actually order of this time, they have still the month of October. So it's one. After I started my school.
Did you receive these notices of 16th of January 23, 24th January 23, 15th February 23 for hearings before the appellate authority? How have you mentioned in the writ petition? What have you mentioned?
That was process, with the petitioner was-
Very well. Neil. His grounds in appeal ought to have been considered. Even if he did not appear. affidavit of service টা উপরে লিখে দিতে বলবেন।
I don't have a brief of this petition, my lord. I've got a
My lord, item number 18, my lord, I beg to appear virtually, my lord. My lord, I am led by Miss.
But you have not served the respondents. That is an allegation against
in
you.
fact, I have asked my
Personal.
senior to take a copy from them.
My lord, I'll definitely check it out, my lord. I think it has been served, my lord. My lord, let me
Service
come
will
back
not be
next
please
week, my lord.
serve a copy on the learned advocate on record for Mr. Kundalia.
Definitely, my lord. I'll, my lord, kindly keeps the matter next week, my lord. In the meantime, I shall comply, my lord.
You have copy. Very good. Listen in.
Thursday week.
Mr. Kundalia, learned senior advocate, appearing for the respondent number.
I am for appearing for the customs department.
Appearing for the customs authorities.
Miss Aishwarya Raj.
Yes. Appearing for the respondent custom authorities, submit that a copy of the writ petition has not yet been served upon his client. Full stop. List this matter once again on November 27, 2025. Service on the customs authorities may be completed in the meantime.
My lord, grateful lordship.
A copy may be handed over to my juniors.
Or you serve a copy on the.
My lord, I'll check, my lord, if it is already been served upon the department, then my lord, I will ask my learned senior friend to have that copy from the department. Otherwise, I will provide a copy itself. my lord.
Why you serve a copy on them?
Definitely, definitely,
Serve a copy
definitely.
on them.
Yes, yes, lordship.
To my chamber. If it's no difficult, kindly.
ওখানে লিখে দিন যে service may be completed in the meantime by serving a copy thereof upon the learned advocate on record for learned advocate on record assisting Mr. Kundalia.
Grateful lordship.
My lord, I am appearing for the respondent number 2 and 3.
Very well. I have written customs.
No, that is not. Later.
Very well. Once. Next. Keys. The car. Not today. No.
দাদা করে দেবে দাদা করে দেবে শোকজ অ্যাডমিনিস্ট্রেশন অর্ডার থেকে
Only one day accommodation. Not today, not today, not today. No, no, not at all, not today. Not today. Not today will do, or you want next week? Alert. It is submitted that service upon all the respondents is not yet complete. Full stop. List this matter once again.
Case number 9, item number 9. That the period process to 2019-20. And the last day of filing the return was 31st March 2021. And within 3 years, it should be filed within 3 years, your lordship. The order should be passed within 3 years. But they have passed it beyond 3 years because of the extension by a notification. Which contains the majority, if there is a force majority, you can extend the time.
You have challenged the notification also. So, Mr. Chakravarti, it has to be admitted. Huh?
But central has to be made a party. I don't know.
Oh, yes.
Central has.
You make them party, you have to serve them notice. Right.
No, central has not been made a party.
Yes, central government has to be made a party. The as rate for leave is granted to the petitioner to add the Union of India and the central CBST authority as part.
Very visual. But taking the technical point, but still some of the judgments of various high courts of recent times have there is no signature, different signature of the GST 01. GST 01 does not contain any signature. GST 07 does not contain any signature. There is a high court. There indicated in a high court. Relying on a judgment of the High Court. Paragraph 37 and 31.
So, because
142 rules.
Yes, Mr. Chakravarti. It is submitted that the order is non-S.
But first of all, I don't. There is one judgment of our case, and I'm not having it at this moment.
Bring it.
Because what I kindly appreciate, these are all uploaded. So there is a sanctity to it. It is not something, it is not uploaded. My learned friend possibly has not annexed, possibly the detailed show cause notice. Possibly, বললাম। করেছো। Sorry, normally পড়ো তো। And let me also see the original papers, the quality of Xerox also doesn't seem to be very good. Let me go to the.
Very well. When do you want? When do you want?
Next week.
December.
Next.
My lord, my lord, item number 23, my lord, I am appearing on behalf of the petitioner. My lord, my lord, am I audible, my lord?
Yes, yes, you are audible.
Oh, yes. My lord, only thing, my lord, it will take, I have actually challenged, my lord, the search and seizure. And on the date of the search and seizure, my lord, I was forced to, coerced to pay 10 lakhs of rupees as a voluntary payment. But my lord, only thing, my lord, it would take some time. And so I am praying, my lord, that I will not be able to complete my submissions because it is already, my lord, only 3 minutes left for the original site. And I'm also out of station, my lord, in Jalpaiguri, appearing in the Jalpaiguri bench. So, my lord, may I pray that it may be fixed on another date?
Yes, yes.
My lord, only thing, my lord, I am praying, kindly accommodate me, my lord, on 8th of December, because, my lord, last night there has been a bereavement in my family, which is outside Kolkata, and I might have to go
So you
rush
want it
it
after
else.
it? After
8th, my lord, I want it. 8th, on 8th, my lord, 8th December.
as prayed for by the learned advocate appearing for the petitioner, list this matter on December 10, 2025.
I'm grateful, my lord.
Affidavit of service filed to the request.
I'm grateful.
Yes. Straight way order is passed.
Should not be.
What, you want to take time?
Yes.
Mr. Chakravarti, learned advocate appearing for the respondents. Which matter? Original time matter? How long will those matters take? I don't know. These are big matters. You can finish it in very well. কালকে তো original side একটু আগে করে দেবেন যেতে দুটোই হয়ে যায়। I'll try and fix it early. We'll finish today, so. Because motions will be held up that way.
Recapitulate in a very, very short time. What I challenge was this notification issue under the.
Yes, I have it. Notification was not published. One. Second is that it will be enforceable only if it is made known to all in the manner known to law. Third is that it is not multi-origin. The ingredient may have been imported, but the actual product which was exported was of India and it cannot be multi-origin. So,
What I said was that I have made a declaration. If you are under the statute,
Section 30.
it qualifies the industry terminology for export of. One is wholly produced in India and one is not wholly produced. These are the two terms which have been used to the control order. And it also provides the form in which I have to fill up the form and deposit. Here, if it is not wholly produced, I have to give a list of the which I did. And in my description of the goods and documents, this was mentioned in my imported goods, made from imported was given, and that we have already specific documents to the fire department to make after releasing all documents filed by me, which was an act of assessment done by me. And this document do not have any words like multi-origin.
yes, I remember. The multi-origin is not defined in the statute anywhere. It is not there. It is not there even in the control order.
The control order doesn't have to do it. Because I was thinking that this concept was first time thought to be brought by this notification. I can referring it as a trade circular. They are saying that it's for the first time so that it can also this higher. On this instruction, I will just lay what the rules require for the purpose of declaration and what department has so implemented. Comparison which I have given
Yes.
Section 1, section 2, section.
Section 2C, where is that? Which page? Yes, I'm seeing the manual. Page 172 is this order. What order is this called? Export control order. Yes. Yes.
Thereafter, Melody kindly comes. Page 177.
Yes.
Non-frequent application for non-frequent flexibility as stated in non-preferential assets. Every exporter that trying to operate a non-preferential position with respect of each consumption of policies, we simply say to the licensing authority, in office of the board or to any provided that are not then there are rules for revision of the rules they are every desire guidance also not to export. Ensure conformity with the following rules the position of export and submit execution for document and attached to the necessary origin and now, but page 197 is the form. To do what person people become mentioned in the page 1 is the form.
197.
Format of certificate of origin not existing then origin can be origin C note. Then can turn with the page 1. The note.
Yes.
Roman 1. Criteria to obtain the exposure of for obtaining only produce and not only produce and only produce are not there, not only produce we are. But I am mentioned the IR. Or not only produce items to them, and thereafter 199 plan I did this, and thereafter very important educated body is the department after all documents etc. Documents. Certificates are given by them. Now, after that, I will take it out to school.
Page.
And users of non-preferential the licensing authority or in the office of the board close the or in the distance which is caused to writing and the particular copy of the office to pass provided that before passing an office An order of issue of a license of denial of this
Yes.
not studying the above any technical of valid in the exercise of the student to be technical and get technical. So it is valid. Thereafter, then there is what I will have to look one another can it might hurt the form your minimum certificate is one the certificate.
Yes.
So certificate order or clearance order now we see
Page 90. Page 90 you are reading. Oh. That is what I was searching for. 90 of the petition. Yes, page 90. Yes.
now they are
Yes.
now final destination coupled with the other documents, other by the department
Yes.
Format is given by the department. By that standard, and an order or conclusion of export was for their side. And I think so accordingly. Thereafter, if there is anything wrong in the matter of appointment, the matter all existing knowers, principles of self-Calcutta apply, and now we have answered. And that so as one that I see as a part of the things cannot be managed. It has been done as a substantial part of the regular by the collective proceeding of that I have this mental I have in my input. Yes. They need to change. Department will change. Department better. Department will be considered. They will all they thought why they want to the matter is from taking across the table. Because result what will be going to that what toxic and not you have to correct it and you have to do it and they do an order. And it can be done which is something very secretary jobs so far is mentioning secretary so actually so if this is not or anything relating to of after that when they see the word and what I understand is multi-mother. If the person has brothers, we are multi-brothers. Or multi-father, if somebody has this, and required better multi-original is a concept or in the word under or I remember my own word, but I am taking very complex.
Reply you have filed. Reply you have not filed. Asked you. Record করতে হবে।
This is not the biggest study, that you work like anti-oxidants. Rather your existing with data and you work like I didn't know to my second point is that when I have talent, the ability of the institution in myself.
Page Page 42. Yes. Yes, yes, please.
Yeah, now I show you the last one who I committed. Deputy chairman, and executive. Now, I was just, my God, that, you can see,
Please. Yes, yes, please.
power, and the licensing authority. I have been officer of the board. Then by the
So licensing authority is chairman, therefore, and there is no delegation, so therefore this could not have been issued by or the chairman. Yes.
Not that in this control order, here we are discussing, at page 191 the tax not provided here under the statute. If this is not provided in the delegate recording of the time by the other participants. Or the technical.
Yes.
In my application, and I okay, I will see that it's becoming tablets and I will set the diagram and people have looked at the very simply and what was the color and what is the not there. And there are the third kind of that the origin has a geographical meaning in various and those that it is an exception by exactly what one the question so particularly time by this slide one day or
Yes.
finally come 1,500 feet. This is the point. Okay. Now we can take some stage one.
Yes.
So what is not the difference? This is under the foreign policy custom fact. Everybody has to comply, otherwise they can't export. Because export is taking the goods out from India to outside India. And outside India is only permissible by qualified and what is the act. We manufacture the goods are as under. Goods are manufactured by exporting that's for definition of the paragraph 7.1 of the foreign person that is imported has been used for production of export products. Export products can not only with the get input and then go back to that include the body. So when we feed then good become now this 1% that they affect a paper. Manufacture means make the wood assemble process in the existing documents actually need to directly use process of packing So he will be branded with in procedure. And the starting today, I myself can put it and calculate it in my passport. That's how we can find it one. I start with a start. So we get on it. These are the actual soldiers who bring foreign money from outside India by this country are. And what it says, see in this, I myself can give irrespective of their action in my involvement document that this is a product of the country.
Okay.
There one thing, so this is foreign trade policy notified under the North Asian Development Act and statutes. Currency certificates are holding from valid preferential trade agreement, free trade agreement, comprehensive, etc., and this is the aspect you do it. Manufacturers who are status holders are too fast, or
No, it's not. I can tweet
the
it.
manufacturers who status holders have approved exportability entitled self-certified their manufacturing sheets from India, which they do to qualify for differentiated. Alright, this is an aspect of it. You take small orders under for the trade, this is Ministry of Commerce. Holding under Ministry of Commerce. And Ministry of Commerce has made this notification and foreign trade policy in access to the power of statute. It says I can do of my own for the purpose of export, etc. They don't want that in export to their see embargo created by the local person who play at the local level. So still we go into it. Still we go into it. But this document of my employee is really not meant for that. It is meant for my export purpose in India. This is that for the purpose of export, we have done the flags. We have even municipal law applied only in India. That's all. When I export the goods, international law as framed by Dr. that what a invoice to declare and dispense, that has to be complied with. And all countries government make a record. Yes, a uniform law. They have signed treaties, and all their laws, regulations, treaties, and originating goods are same throughout the world. Now, one person is trying to do a theory kind of a thing. By that, I do maximum loss to myself. I am people who are to protect the and encourage the export of it. And when we see are being exported to examine it, and when those were buying it, I think the food test. And unless these tests quality qualified, their imported food test, it won't be better. And they won't be accepting the food. Just quality particularly when I'm exporting European countries, when standards are very high. Food standards are even since fertilizers are not allowed to certain limits and the that level is high. That is what I do that. So now what they say in the ability I do is that I have shown the putting of identity that is really made in their activity and position without any document, without anything. But I will come later. I will go back to my discussion that what are the challenges which has to be if they face in their there. Well, the paragraph 16 as stated out.
Paragraph 16. Yes.
But these are not being denied by the 17. that export trading is dented to follow the order which is called category, while exporting the information of this not denied. Paragraph 18 is not denied. Paragraph 19 this on this offices of etc. Involving the business sentence of the black piece standard etc. Involves further etc. Not denied that if you are following the principles of custom tax, quantity is not denied. That's it. And paragraph 1 is what is the meaning of the consideration. And at the page 10, I have stated this that the trade notice dated by one trade notice by having the notification part of the subordinate system that non-statutory exists centrally law. 23, 24, 25, 20 are all not there. 29 is what I do that. What I when I import the goods, I captively consume. If imported, this I have mentioned, it is not being denied. It could not have been. So means that does not remain anymore. When I use the imported goods to captively consume, it is over. Consume for that purpose. It is not being denied. So then page 14, paragraph 30. That includes this notification illegal, contrary to substantive law of the country, does not have an substantive law, and it cannot have conflicts of constitution. Paragraph 24. That trade notice affects to amend this. And lastly, very quick very fast. Paragraph 29, I have challenged that the notification without authority of law, without jurisdiction, very derogation, and contrary to substantive purpose. After this, when this is challenged, and even my lords directly said in that case, you will come up with notification of government. Can you do physical or basic and then they could be in the public document. But what or whatever and that was the question. All the a notification is substantive law. If you have have access to the food that say one again. See that say one talking about intersection of the
Yes.
Order, if you want to click on that one, the subject of the state concerns more than 1% more between you taken an order which is under all the departments that concern or claims for taken or other arrangements that clear here the person has gone to the direction of the system of the order instantly. They have acted like this. The more reference were they one anyhow. Will you thought that you can take it or this particular there is nothing that they refer when happy. That is by that was has complied with the conditions required for inclusion of it. And thereafter it says it must be done. And when it you said it has to be done. And without that it is not permissible. I don't know that much later. But this thing nothing. Now all over the world. But that's great. When you see how by exporting multiple whereby governments describing and the government has done I'm shocked. He says and he what he says thereafter. Declaring as majority, I think he says हमारे यहाँ तो सब लोग बगैर शक्ति है. I am shocked. How the politics government can move around. But it is said like that. Then, that something about. They are going to be very much available on the next year. No, I am talking about again, they say very much available. Then, and the other exporters are going to by the strategy and and one thing is very factor is that no one can have and say that who does no inspection of documents or transaction. I don't think that talking about I allowed it, I ordered document. After level of five receipt, but I don't see. Then they have to examine. They have style limits for examination. If you ignore an order, this is set and so government has for that. They are compromising all okay. I'm not even
We are not
I told you, friend, I gave you complimentary. I gave you most complimentary.
We are not complimenting.
Happy, happy.
If we want to do a thing.
Happy, happy. I said, this is what the application is now about the participation of it. They have analyzed that one document has failed to be. This is what they say. They have changed it. But we did it. How many persons made? They are or but they do not work with that. Then yes, at the bottom is not. How do you see the head? You don't see the body. Next document change. This notification is not. Now we after this. I wanted that and very the speaker very very one staff is nothing. And then I wanted to see what the notification is from the board. Which is printed. Then what we got is like this. This is like page 148.
What? Yes. This is the same notification.
But this year is that becomes here we see a part of the past from this system. Where you read the word, but it's a system. Wherever we exercise the power of control and the powers of the key act from the can I there is a significant system. I go again and it is like action is not there. Action is not there, notification is not there. Who can specialize in notification by artificial method? Nobody can. We really accept it that this is the level then we can actual time to say that website we have to website also do the same. In that case, there is no extent. All copy code, all copy code. That is nothing like that. What can't be accepted in a subordinate territory. No, I just
Very well. release করবেন other matters release বলুন
Another one interesting thing I have given. Again, Marathi wanted to take that also. There is a number of zero one. 132. This number is given to the postal address to whom the letter is sent. So a source model is sent to Calcutta. One to Department of Supply. All other people. Then this number are given by and so as to identify who fees has gone has got expired note. This can't be in a status register. It is not that it was put on the website on the day one. That is why it was written. This is not a document which one is, but this is the website for the purpose of notifying the public. For the purpose of notifying the public, it was one. Not that it is simplification. So as a sample, I put another. This is not the. It can't be. So far I understand this for these facts and these things. They are required to happen. The answer is clear that the person who took has the authority has the power or the authorized and the authority that they are annexed the authority letter in the application of the person who files the application as but the person who can issue the he's not here. And he is not no awareness. No awareness that notification has been lawfully issued to the government. There has to be an awareness that application was lawfully issued by the authority to the authority. So these notifications are otherwise invalid. So and another one these notifications I will tell you that even suppose I say that is I was dedicated, I forgot to do this to the notice or I did file the act then actually yes I won't place him out of that. I will place it. He has doesn't allow to this kind of that this can be done. This no such permission or delegation is there in the company. So if in the main act there is no power of delegation, a delegate can't delegate. I think is that first I was challenging this those motives that it was temporary to the notification. Then it was also temporary was as a person who has no authority because page 109, 108 of the total something not good. The issue by Japanese government. So this program start this is why the Japanese government because the recent country China
Page. Yes.
So it can be issued only by the writing authority, the writing authority is there. If 47 dollars allowed. No, so if you get it, they're all this 34. So what this focus is also backed by the authority of law. No, I was also telling that order
Control order at page. Control order.
power conferred by this power of the
May I just interrupt my answer one? But kindly to the pre-act of the issues. No, kindly this unnecessary, he is not, kindly see the prayer. He is expanding the scope of the representation. Can you see the prayer? By your supplementary review, can a controller be challenged? I am asking the question to myself.
I close this supplementary affidavit. In that supplementary affidavit, I had mentioned that this control order is also valid. It has complete order accession. Court accepted that supplementary affidavit, etc., and it was part of the record. This was really a point of law which I was asking. That this control order and the fact events has to be set on my amendments, got an authority to file application after board has come in, and I have referred to supplementary affidavit number of times when I was making the case at earlier time, also when the matter was earlier heard. So it is not that something new which is says that validity of this control order is not the part of the document. This has been added by supplementary affidavit.
But by supplementary affidavit, you cannot challenge. You have to, you can make submissions and pleadings, but prayers have to come by way of amendment then. But then there has to be a challenge. Then also there has to be a challenge. Without challenge being thrown. Because there are judgments which say that if something which has not been yes. But that is pleading.
by supplementary affidavit.
Because there is a judgment of division bench here of our court. If I correctly remember, it's by when Justice Mathur was the Chief Justice. The matter was argued by Mr. Kapoor, Mr. S.K. Kapoor. There it was decided that by way of a supplementary affidavit, no challenge can be thrown. Prayer, you will have to file an application for amendment, and this technical point was taken, and it was it binding on all single benches.
Type of cases, there are plenty of judgment on both. For these matters, there are plenty judgment on
No. So, for so far as this issue is concerned, by way of a supplementary affidavit, you will not be able to challenge. By way of a supplementary affidavit, you can support your pleading. But if you want to introduce a prayer, you have to amend your writ petition by filing an application seeking amendment of the writ petition.
Not only so, my lord, your lordship, my lord, kindly recollect. Even if in a central legislation, if my landlord wants
And then control order is on a different footing. If since it is a sort of, it has a statutory character, you will have to issue notice to Attorney General.
he has to give notice to the attorney general.
given notice to Attorney
No.
General. On very first day, we have given notice to the Attorney General. Very first day before moving in, this point was there, this was this that we have given notice to the Attorney General. And so far the prayer is concerned, whether this supplementary had come in, the very first day I have filed the writ and that it is not that my supplementary has come much less. When I filed the writ, I did not annex at that time that control order complete in my writ. My fourth matters, this and this affidavit came together. It came together. So it is on the same day. And the same day what I said in paragraph 4 is this that about this and challenge paragraph 6, 7, 8 and 9. These are the challenges where it has to be confined to that is this ultra violet to the TR. What I am saying is this ultra violet to the TR. Even if without going into the technical of this, when I argue that this notification has been bad in law, I can also argue, I think also bad in law and consequently or bad. Consequently or bad in law. So it is not really a matter of its next against.
So far as your challenge to notification is concerned, that is there in the writ petition. Notification you can always challenge.
Challenge for another notification is bad because it's main order. This I cannot.
The main order has to be challenged because notification is consequential.
That notification is bad because its mother control order is bad.
No, but that mother control order is bad has to be proved and has to be challenged. That challenge will come by way of a prayer. If without doing that you can sustain the challenge to notification, you can go ahead.
You can then if I can be able these are the points of the law when I say this notification is bad because of the and then after I say its mother notification was also bad. Now if one can't say this for this point of law, one ground of challenge of validity of the notification can't be but stop and this stop.
No question of stoppage. Since you are saying that a control order is bad in law, to hold that it is bad in law, the court will assume jurisdiction when prayer is made.
They don't declare it like this. While they're dealing with contention of the
Yes.
that
Very well.
notification is this and this one.
Very well.
And as adult, my lord can treat it as write down and it is in this and there are hundreds of elements that these particular methods are handled. And particularly when we are in the writ court. Writ court, when we say no procedural requirement is required at all, it says case can be treated as a writ application.
That is for persons who are have not for everyone. Bandhua Mukti Morcha and all those cases.
I taking your this that is I think these are before that, I will. Page 8.
Petitions.
All of this as this compile, I think,
Page 8, 38.
yes. Page 25, six months.
Yes.
Chapter 4.
Yes.
Control over export of tea and tea. Control of export of tea and tea. This is under this chapter 4 covers about export quota license, special import license, connected to that. Now, under which the rule has been met, that is under chapter 6. Can we have a broad coverage of chapter 6? Power to control price distribution of e-waste is not there in this case when we make out this kind of activity is not applicable. Controlled by central government for this axis. Power to control price distribution of e-waste, it is not covered in this export license. Subsection 3 of this central government made by research is not coming. 5. Without prejudice to the generation, trade, etc., production, supply, distribution of trade, export is not there because it is covered specifically there in chapter 4. Then, the rule-making power is given only for the purposes of the subordinate legislation cannot be made beyond this authority given. That there are a number of judgment rights of this. I can give cases and recently the Supreme Court in that of that I don't know when it was high, then the court held it that subordinate legislation can be challenged on other ground also, and this their state paragraph 27-22. Gaurav Kumar versus Union of India, 20251 SCT, page 641.
Yes, yes.
I was the last point of view that if at all this is a notification, then there is a conflict of law. A subordinate registration in direct conflict with the Customs Act. In my opinion, I have said this, they have denied. A subordinate legislation, if it is there, which I say it is something like a letter, and the body of that is like a letter. That writing. So if it is a conflict, it doesn't start with the non-authentic.
It could not. That could not have overridden any statutory.
Any statutory will start. So this is also starting law. And one thing very important and interesting is the that when all these procedures are taken, suspension, assessment, in our all act, there are authorities within the mission of that who do this. Under Customs Act, it is section 4, 5, all officers of the PR's officers. Under Income Tax Act, under section 1, 4, or commissioner hierarchy is there. They are officers of it. Now, anything is proceeding is being initiated under the law by an officer of that. It is there, this or an officer of that. Then officer of that has to be defined. This is officer of that. You kindly have a look at the key. There is nothing. Phase 2. Yeah.
Yes.
Definition. Keyboard is this. Then vice chairman. Board shall be elected members to serve the staff. Function of the board. Then control chapter 3 is not there. And
Section 8, 9.
And nowhere is there that who are the authorities at the staff and we can operate.
Section 8, 9.
Section 8, 9.
7, 8, 9.
7, 8. Executive and other committees.
Read section 7.
Keyboard. It is keyboard. How keyboard is there? This is not so. The establishment of keyboard, board shall consist of a chairman, such number of other members, not like 40. Then PA, that officer shall not disqualify for I am not reading 5. Any officer centered on statutory voting, it can be vacancy, fixed salary, vice chairman, board will elect among its number vice chairman, in executive and other committee. This 9, central government shall appoint deputy chairman. Subject to this, board may appoint the employee, etc. Functions of the board. Regulating production, including production, distribution of the board. This is what we are. Generally, what happens and the statutes are a hierarchy is being given by this 116 under the custom tax, under the income tax, income tax authority. It talks to the this is being given.
Yes, yes, I know that.
In the custom tax, the first thing there is who are the authorities under. This will be the beginning of this time we have to look at this custom tax. Now how classes of officers of that section 3 custom tax.
I have something like that.
But this still wrong. Yes. How more can function? If it is said about the assessment license, etc. Licensing authority is issued a license or any option, no direction. Then how license can be issued in the act? There is such a lacuna, or what I will say is not a complete code, or is still born act, which cannot walk because nobody has been able to point out how who will be doing assessment. Well, I will be taking that suspension order, issue of suspension order or assessment, etc. Who will be doing it? That 27. If I give it 20, I will do my if I just give it. I will 4 regulations under which the officer is excluded. Power to issue directly by legislation or any officer of the board. Service of the order, any order, direction, nature of by any other authority of the order. Who is any other authority of the act? Not there. Assessment, issue of license, issue of everything is licensing. Everybody is licensing. Nothing of these somewhere delegation starts in this order delegation of in this other one delegation is permitted. Here in this marketing control order delegation is not permitted, but I am confident. So this is an extreme problem. Every function of there is Overall notice, issue of license, every action of them is in fact null.
Now you are going to height of the sea.
Yeah.
Now you are going to the height of the TX.
No, I don't, yes, to be.
Yes.
What when he had the move, the court had said that you reply to the and other kinds of things where things legally had gone for our 115 meters for the we were told that another 130. Then he asked me how much you said. It is 1 hour. 1 hour. Then he said, I can't. He was in the rush of going, I think, Bihar. He was the officer of the anyway, person who was hearing my court was working whether my license to be cancer, which made my 800 employees jobless, my office shut down, my all the license shut down, has not 1 hour time to get, but he has a nuclear button by which he can do entire blast in 6 seconds, not 1, 2 seconds. And when we will try to get them again in the court, it will be hundreds of these एक सदी का एक moment का गलती सदी correct. This is no hearing at all. This thing, what was done was unacceptable thing, which was really had. I've never faced such a situation that I have no time to hear your then appeal. I will decide on the merit of the case, merit of the matter, or on the pleadings. Then what for hearing was there? If hearing is not hearing not the issue of case that you will hear on the basis of document. That is, I had a pinch of that. Something which I used the word had an effect of how I was treated there in this gentleman on the in course of studies. It was as if they are monarch. And we are all are subject. All is my character more than that is just the kind of the feeling it is not a matter which the security authority does or something. What I said is that there must be a reason of
obviously this should not have happened.
If it is so, then
They are officers of court and
yes,
advocate.
I am the last person.
These things should not have happened.
Huh? He is saying that they argued near about 1.5 weeks. Should I start or?
Yes, we still have 10 minutes. So we'll touch upon something because thereafter he'll have time to reply. So it will. I will not keep it tomorrow. I'll keep it some other day because other matters will suffer.
I will not kindly take the writ petition first.
Yes. You will have to justify the notification.
Yes, I'll just
the legality of the notification.
Yes, I'll just wait.
Because it has been shown to be contrary to many acts.
Yes.
And there is an allegation which has substance that the notification does not refer to a main section. If it is a notification which has the force of law and if it is to be read as a statute, then a thing which is not there cannot be, casus sumises cannot be supplied by court. What will happen to that? So these are questions. Yes.
Now, Willard, your lordship, Willard, kindly text, Willard, writ petition, Willard, paragraph 19, page 8.
Paragraph 19, page 8. Yeah.
May I just
19, page 8. Yes.
Now it says, my lord, on or about 7th April 2025, the officer of the respondent visited the petitioner's office premises and seized the invoices of the export of tea made by the petitioners in the recent times unauthorizedly. The invoices of the petitioners contain description of the goods, such as black tea blended with imported black tea packed in paper sacks, which were filled up by the petitioners with the respondent for grant of license. The invoice has a column country of origin, which is necessary for the international trade, where the petitioner mentioned India. The country of origin of the goods needs to be mentioned in the column of invoice following the provisions of the Customs Act 1962 and Foreign Trade Policy notified by the Government of India. Now, my lord, next, my lord, if your lordship, my lord, kindly turn, my lord, page, my lord, 9, paragraph 22.
Yes.
Paragraph 22 says, my lord, the officers of the respondent number 2 objected to the invoices raised by the petitioner in respect of the export of manufactured and packaged tea with the imported goods mixed with the Indian goods, where the description provided use of imported tea, but the column of the country origin where petitioner mentioned India was objected to by the respondents on the purported ground that it should be multi-origin. In terms of the trade notice dated 22nd of December 2021, issued by the respondent number 1. The trade notice issued by the respondent issued and addressed as if it was a notification and part of any subordinate legislation. When it was a non-statutory directive contrary to law, a copy of the trade notice dated 22nd of December annexed. Next, paragraph 32 says, the said trade notice was referred to as notification has never been notified in any gazette in the manner prescribed by the law under Rule 32, and it cannot qualify the path of subordinate legislation. So, below, my learned friend places this that this directive issued, it was never notified in terms of Rule 32, so it cannot have any statutory effect. Now, on the basis of this pleading, Lord, kindly see what prayers he has made. Lord, kindly turn, my lord, page 35.
Page 35.
Yes. First is, my lord, a writ of or order or direction in the nature of statutory commanding the respondents, each of them to certify, transmit before this Honorable Court the notification dated 22nd December 2021 being annexed at P3 to the petition, and the Rule 27 of the Tea Distribution and Export Control Order 2025 being set out in paragraph 46 of the petition, and the impugn so cause notice dated such and such be quashed. So, my lord, kindly have a look, my lord, what is the notification? You have also seen it, my lord. There are two notifications. First, at page 42. Page 42, my lord, it says, my lord, whereas in exercise the power under subsection 3 and 5 of the Tea Act,
yes.
Your lordship is saying, well, section 30 is missing. Well, it is a fact, section 30 is missing. The Tea Act, the central government has notified the Tea Distribution and Export Control Order 2005, herein number such and such order, to exercise control over export, import, and distribution of the imported teas in India. And whereas under paragraph 3 of the said order, that no distributor shall carry out the business of distributing imported tea, or no exporter shall export teas or export imported tea except under a license obtained in accordance with the provisions of this order. Whereas under paragraph 34 of the said order, the licensing authority can issue any direction relating to import and export of tea. Next, whereas it has come to the notice of the imported teas are being passed off or exported after blending with the teas in the name of the Indian tea, which reduces export competitiveness and image of the Indian tea globally. Now, we learn next. Now, we have in exercise the power under paragraph 34 of the Tea Act, Distribution and Control Order 2005. It is hereby directed that the exporter shall clearly mention the origin of tea in the packages and invoices while exporting. Any tea exported as Indian tea or as any nomenclature of the Indian tea shall comprise 100% of the Indian tea And in case the Indian tea has been blended with the imported tea, the same shall be exported as multi-origin tea and should not be marked as teas of Indian origin. Under any circumstances, failure to comply with this direction shall invite action as deemed fit. Now, my lord, this notification, there are two notifications. Subsequently, there are another notification that is page 43. Next notification also, my lord, issued under para 34, last paragraph, it says, now therefore in exercise of power under paragraph 34 of the tea distribution and control or export control order 2005, it is hereby reiterated that all importers, whether importing or re-export or distribution and exporters, shall immediately obtain clearance certificate from the tea council portal of the tea board before importing or exporting the tea. Now, so far as this page 43 is concerned, my learned friend did not challenge it. Now he is complying with this notification. This notification was also, issued, my lord, in exercise of the power under subsection 3 and 5 of section 30 of the Tea Act. Now, my lord, it has to be under section 3 and 5 of section 30 of the Tea Act. Otherwise, there is no meaning at all. Well, he has been complying with this notification.
No, but this is challenged.
No, page 43 is not on a challenge.
No, page 42 is the same as page 43.
No. Page 43 and page 43 towards different. Both are different. Can you see? There are two notifications. I don't know, my lord, which notification my learned has challenged, but there are two notifications. By instruction is, I have also stated in my opposition that he has been complying with this notification. That is page 43. There are two notifications. One is, my lord, you also can see kind turn page 42 once. It is reference number, my lord, 123L C import issues 2021 13201. Next one is 13202. But my case is, my lord, he has been complying with this notification. And I have stated on oath in my opposition. So one cannot be
13301 he has been complying with.
Yeah, 13302 he has been complying with. Next one. Page 43 he has been complying with. But so far as page 42 is concerned, he is saying that I do not know what is the multi-origin tea. His main contention is this: I do not know what is multi-origin tea. Number one. Second contention is this: notification never seen the day. Third contention, it was not even gazetted. Fourth contention, it was not published in terms of Rule 32 of the control order. These are the 4 points, my lord, my learned has urged. But my first point would be, my lord, page 43 he has been complied with. So there cannot be hot and cold on the same breath.
Forty-three is being complied.
Yes, 43 has been complied. Maybe on next week, Milan, I'll
Next
complete.
week.
Give me, Milan, 40 minutes time.
Yes, yes.
I'll complete.
Next week will.
Next Wednesday, it is for Milan.
Next Wednesday. Listening. Heard Mr. Mehta, learned senior advocate, appearing Mr. Mehta has concluded. somebody is designated as
Yes,
a
yes,
senior advocate,
absolutely.
even if he is not, then also and
Then
he is
I-
designated, then definitely.
100%. There's no
They
doubt.
are all officers of court.
I'll take care of
That is
that.
how we have been taught.
Do have been taught. Yes, there's no doubt about it.
नहीं तो एखाने देखे नेবেন অনেকগুলো কাগজপত্র দেখে নেবেন। Thank you.